Well, good evening. Good evening. Happy September, entering the 9th month of the calendar year, September 5th, 2025. I apologize for my tardiness this evening, but we are on Rob Standard Time. And to be quite candid, I was distracted because someone decided they were, rather than phone in or give me a phone call, they just decided they were just going to join a live stream to fill me in on their day. So, Ian, I brought you on stage because I know that you're currently operating a motor vehicle, I believe.
Yeah, you're on speaker. I am not touching or looking at the phone. So
yeah, that's the smart thing to do. So, how you guys doing? How's everyone's week? It is now the month of September, which scares the living daylights out of me because that means that we are entering essentially the fourth quarter of the year. And my brain is still, I think I'm stuck back 2 years ago, but that's just the way that life exists right now. But Ian, you were the reason why I was delayed. And the reason why I decided that I needed to go live and bring Ian into this chat and conversation, because Ian went to the store and Ian was looking for a very specific thing. And he was looking for a 1-inch pipe.
yes.
And he was looking for feet of 1-inch pipe, but I said, you can't say 1-inch pipe and not do it on a live stream.
So yeah, I needed some 1-inch pipe, and the problem is that the pipe was too long, and so I needed to have it shortened, and I couldn't find anybody in the store to actually help me with that. So finally, I managed to track some people down and be like, I need this to fit in my car. They're like, okay, I think we have a hacksaw somewhere. So
I candidly did not know where you were going with that, because literally the only part of the story you got into was the fact that you were looking for a 1-inch pipe, and I didn't hear any of the rest of it, and until you graced us with that you needed to shorten your 1-inch pipe. You couldn't find anyone to help you shorten the 1-inch pipe. So that is how we are starting off this live stream, with an abundance of maturity that would otherwise not exist.
There were a couple of nice women there who helped me get it smaller. So,
oh my God, this is so much worse. And we're off to a start. God. So, anyways, how we doing? Ian, you had quite the exciting week this week.
Yeah, I had a break and enter attempt. So that was fun, and by fun I mean yeah,
which was conspicuously timed with a certain announcement that was made.
Oh yeah.
News.
Well, we had
God.
We had Sean Fraser, the one minister, saying, "Oh, you don't need to defend yourself. It's not the Wild West." And we also had the York chief of police who did did like a press conference where he said, your best defense is to comply. Just give them what they want, and be a good witness later. And I'm like, that's stupid. But what is it? Yeah, I mean, thankfully, no one was hurt and no one was home when it happened. I was actually like 3 hours drive away, and I just got to see that it was going on the my doorbell cam right up until they destroyed the doorbell cam. So I got to replace that thing. But I mean, it did good work while it was there.
I won't show the doorbell cam because that you have not posted, but I will show what you did post on X or Twitter.
Yeah, don't share the doorbell cam because it could probably identify where my house is.
Yeah, not doing that. Not doing that. I'm just showing the door, that we are not talking about just the run of the mill, like, hey, knocking on the door, wiggle the handle. They actually cracked the door in trying to get into the house.
Yeah, there's that vertical split that, assuming you're showing the picture, I'm assuming you're showing. There's a vertical split that wasn't there before, and you can see like a clear prying mark. And I'm pretty sure that's probably a screwdriver, like the round handle. And probably trying to pry the door open. But I mean, I don't have shitty doors. I've got solid doors, and I've got a strike plate that just does not fuck around. I don't know if I told you this story, but I am like, I'm concerned about home security. So my wife would say paranoid, but it is what it is. So I decided I was going to replace my strike plate. And, the standard strike plate is like a couple of inches with with like 3/4 inch screws that like hold it in. And that only holds it into the molding. It doesn't hold it into the frame. So they sell security strike plates, which are much better, that are like, usually about 6 inches long with like 1 3/4 inch screws to get into the.
I know what you're talking about. Yeah.
Yep.
They find basically it's essentially a piece of sheet metal or steel, not even sheet metal, but a 1/4 inch steel.
Well, what I did is
6 inches and basically drill it into the frame.
What I did was a little more in depth. I got 1/4 inch steel straps, so good thick, much thicker than the strike plates usually are, because the strike plates are usually more like 1/8 or 1/16 for their thickness. This is like 1/4 inch, so good and thick. I actually had to plane away some of the material of the molding in order to get it to to close in properly. And I drilled about I think it was something like 30 screw holes in it, and then proceeded to put like 3-inch screws right into the right good and solidly in there. So you're not moving that short of like a truck mounted ram. And so this guy was running up against a door. His best chance of getting in was to destroy the door. But I mean, destroying a door is fairly difficult. And so he gave it his best go and didn't make it in, which is good, because if he'd made it in, Mrs. Runkle arrived home like very shortly after he made his attempt. And so he almost certainly would have still been in the house when she got home if he'd made it in. But because he didn't make it in, he took off. So, she wasn't there.
Well, and the questions that the chat's asking is the same question that I asked you, I think first, was, were the dogs going nuts? Were the dogs home?
The dogs were home, but I don't know if they were going nuts, because my doorbell cam was taken out. And so I couldn't hear any dogs, there. So I don't know. Potter is in his cone and booty, so I don't think he would have been like super effective there, because cone and booty mode is not exactly built for combat. Zora is kind of a little coward. She is kind of terrified of people she doesn't know, so she probably would have barked, but I don't think she would have like bit. That said, I think she might have if Mrs. Runkle was home, and if it was a matter of defending her people. But I think otherwise she would have just barked at like, "Why are you here in my space?" kind of thing.
Well, usually the bark is actually what you want. That's usually.
Well, the problem is the neighbors aren't likely to do much over like a barking dog. So.
No, it's not the neighbors. It's the barking. Barking usually detracts the breaking and entering. It's one of the.
Well, I mean, he made it. He made a good try of it. So.
Yeah, so he wasn't that distracted.
I kind of figure. I mean, he was breaking or trying to break into a place at 5:30 in the afternoon. That's a time when people are usually home, right?
What a wild what is going on?
This is not a guy who's.
It's not someone who's thinking this through.
Well, it's not somebody who's upset about the notion of encountering, a homeowner, right? That's somebody who's got whose plan is not just to go into an empty place. when a lot of the time you'll see burglars take steps to sort of ascertain if a house is empty first before they try to break in. This guy didn't do that. This guy went straight to trying the doorknob. And, you know, so that tells me something right there, right? So, yeah, that I got to beef up the security, though.
Pretty wild. Well, getting your security camera out of arm's reach is probably one of those decisions to make. One of the things to do.
The thing is, it's a doorbell security camera, right? So it's like a video doorbell.
Yeah.
So it's got to be within arm's reach so that people can actually push the doorbell.
Yeah.
But yeah, he ripped that off. That's like $250. The door is probably going to be another $2,000 to replace, because, you know, now that it's cracked, it's not going to be as good for security. Yeah.
Nobody.
Yeah,
Well,
and I mean, you know, I could make an insurance claim, but the deductible is probably like $1,500, so there's no point.
It's usually not worth the deductible.
Yeah, well, and not just the deductible, but you also have to figure, like, you know, you make the claim, and then they boost your rate.
Yeah, and go up because now they have a prior break-in that they have to kind of consider. This is a possibility happening again.
Yeah.
What a nightmare. I'm sorry, man. That is rough. Now the thing is, the only good thing about it is the door was secure. Mrs. Runkle wasn't home. They didn't actually end up making it into the house. At the end of the day, it's just property.
Yeah, and it's not even like, you know, because the thing is, you know, you say it's just property, but there's a much more invasive feeling if somebody's actually been in your house and so forth. And, you know, a lot of the stuff that we say, oh, it's just stuff, don't worry about it, is stuff that you can't replace, right? And that's, you know, it's stuff you've got like an emotional connection to, you know, family heirlooms. In the modern era, you also have problems with like data. Because if somebody walks off with a laptop, it's like, well, shit, all of the stuff that was on the laptop is now a problem. So,
yep.
Yeah.
So it's all in how sophisticated the individual is that did the breaking in. Now, have you shared what was taken off the porch?
Oh, yes. So this is kind of darkly humorous, and chat, please don't judge me too harshly for the darkly humorous part, but it is what it is.
We're a fan of dark humor.
So the guy who broke in or attempted to break in was very clearly indigenous. You could see that from the video. The video's actually got a pretty good picture of his face. You can see he's got a distinctive tattoo. He's pretty clearly made out in the video. But, you know, so buddy, if you're out there watching this, maybe now is turn yourself in time. But at any rate,
on camera.
You're on camera and the quality is real good. So cops are going to recognize you. It's going to get, you know, they're going to issue a warrant. It probably won't be resolved anytime soon, but eventually they'll pick the guy up. And then I'll have to testify, and that's going to be good fun. So anyway, so at the end of all of this, you know, when he couldn't get in, he stole a package off of the porch. And the package he stole contained some material for Mrs. Runkle's Girl Guides class. Specifically, it contained material about truth and reconciliation, which is like truth and reconciliation with Indigenous people in Canada. So this guy's stolen material that I don't think he's going to particularly enjoy, but it's got a bit of kind of a...
There's an irony to that.
There's an irony to it. He's going to be sitting there going like, oh, well, maybe I wanted the Girl Guides to have this. So
one of the Clueless says, do you think they targeted you? No, I've seen the video. There's no...
It doesn't look targeted.
It looks like he came from the adjacent house where he had tried the same thing. Like it
And
comes
the
in
thing is,
sideways. Yeah.
if it was targeting me, and because they knew who I was, I'd expect them to be like at least 4 deep. Because sending one guy after me is just not a great plan. So, and I guess the like the 2 guys that they sent after Denny Markell, if they caught me in the driveway, all right, we're good on them. I'm done. But if they're trying to get me in my house, well, I don't think that's enough guys.
Yeah.
So,
And Calypson just makes the point. Can we appreciate what it would be like to experience someone trying to ask questions of Ian under oath? As the lawyers, that'll be absolutely hilarious. But we're gonna get to a little bit of that because, not to spoil any of the fun, I mean the thumbnail and the title of the video kind of gave it away, but a lot of people, and I mean a lot of people, were throwing a lot of questions my direction when the family law expert got up and started testifying. And then it was just, I didn't have an opportunity to stream, but I got the opportunity to watch a bunch of other people, other lawyers that I trust and admire, friends of mine, go up and talk about how this family law expert was testifying and how this is wild to them. And I'm just laughing because me, the divorce attorney who's been doing this for 15 years, is just going, oh, if you guys would only know. So tonight, I'm actually give you
the jury doesn't know.
No, that
The jury
I
doesn't
think
know.
was the biggest problem. But yeah, we
Yeah.
got a little taste of what it's like to have a lawyer on the stand and to subject a lawyer to cross-examination, and it can get a little chippy. Really kind of funny. So, yeah.
I mean,
And then
lawyers don't like being on the stand because, I mean, it's not so bad with a jury trial because juries don't make findings of fact, right? But with a judge trial, where you're going to have like a published reasons, it can be a bit of a big deal if you're on the stand and, judge is like, well, I didn't find this witness credible. And it's like, well, that witness is a lawyer. So that's a problem.
yeah, it's a complicated situation. And the other problem is it's criminal defense lawyers are, we'll get to it when we get to it. But I did want to highlight, there was one little story I wanted to get to quickly, which was there's the juror Foreperson apparently came out and did an interview with the Tallahassee Democrat. So I was going to take a look at that briefly before jumping over and going into that testimony. Let me catch up a little bit on the super chats that have come in, just because we jumped straight into hardware store, followed by breaking and entering store, and Ian has been in the car the whole time. I didn't know to catch up anything else. So
I'm now out of the car. So
you're now out of the car.
Tell you
Josh,
what, I'm going to let you go for a bit and switch over to a better machine. So
okay, I'll see you in a bit.
See you shortly. Cheers.
We remove the Ian. Ian removes himself. Joshua, thank you for gifting memberships. Very much appreciated. Very kind of you. Also, mods rock. So if you're in the chat, say hi to the mods. Thank the mods. The mods are great. They keep the chat running smoothly. So thank you, mods, for being here all the time. Lady Fang, I've been looking forward all week to hearing Rob's thoughts and opinions about the family law stuff, especially since that second lawyer was on the stand. I have a lot of thoughts and opinions. Some of them you're not going to like. Some of them you're probably going to feel reinforced by. Some of them you're probably just going to be like, I didn't know that. And then obviously there's probably going to be a story here and there to go along with it to give some context. Things that you can't see in a courtroom, but you can get explanation after the fact. Gray Gold Girl, thanks for becoming a member. Much appreciated. Canonical Heat, thank you for gifting memberships. 20 gifted memberships. Thank you very much. Steve A. So Runkle's reduced to phoning it in, huh? It was his choice, not mine. I was just glad he joined and said hi for a bit. Can I please do all the YouTube things? Yes, please hit the like button, guys. We are currently, where are we right now? We are currently at, where can't I even see? Oh, 622 likes. I'd like to get to 1,000 pretty quickly. So for those of you who are watching, there's 2,174 of you watching right now. Please hit the like button. It takes 2 seconds. Will the real Ray E please stand up? And I just realized that the chats, you guys have your names back. It's no longer the names. There we go. I don't know how it happened. I didn't do anything on my end. I don't think I did. Oh, well, will the real Ray E please stand up? Jailhouse snitch number 3. Are you seriously writing notes on a criminal conspiracy? Possible. I don't know. Baby Steps 22. Thank you for gifting memberships. Very kind of you. Pants. Glad to see you back. If the pipe is 1 inch long, it's called a nipple. Okay. If the pipe is 1 inch, it was 1 inch in diameter, I believe. I did not ask if it was inside diameter or outside diameter. But 1 inch pipe. Chelsea, thank you for gifting memberships. It's very kind of you. DSN, thanking whoever was it who gave the gift of membership to them and then turned around and gifted 5 more memberships of their own. Thank you very much. Parrot Court, dogs are great during break-ins with a bunch of hard face emoji. They are. When Ian gave me that story and told me that, it made me quite concerned. And it was an immediate opportunity for me to remind the kiddos, what do you do when you get home? Inside, lock the door. Inside, lock the door. Make sure the dog is not locked up. Joy Schmehar. Maybe? Did I get that right? Thank you for gifting memberships. Very, very, very kind of you. Kristen M96. What if the breaking and entering guy tries to hire Runkle? Well, that would be a conflict of interest. I cannot think of a more solid case for a conflict of interest than the criminal defendant trying to hire the victim as their attorney. I don't think that would work. Shay B, 3 years, member for 36 months. Congratulations. Thank you for being here for 36 months, contributing to the channel the entire time. Very, very kind of you. And glad to have you here and just ringing in the 3 years of membership with 50 gifted memberships, growing the community. Thank you very much. Baby Steps 22. Rob, I saw the family law attorney's callous attitude as being a total opposite of you. We're going to go through it. We are. I think some of that is in the way that it was presented. And some of that is, it's going to be better when I explain it when we actually go into that discussion about how she presents. First attorney, I thought did a lot better job at kind of taking the humanity or being able to insert the humanity into some of what we do and what we practice. Attorney number 2, less so. But we'll go into that. Mr. Ray Romantico, good to see you guys. Thanks for streaming. Thanks for being here, Mr. Ray Romantico. See, now that we have the stream, the names back, we get to see how clever you guys are. Morgan, Rob, I'd love to hear your opinion of SB's family law disaster. That's Sarah Boone. Although I understand if you're uncomfortable analyzing it. Morgan, I haven't taken a look at it. I'm unaware of where things stand at present with that case. If any of the mods or if anyone has the links to any of the documents or the pleadings or anything where I can get caught up, I'm happy to take a look at it just to give you guys a summary of where things stand. Every jurisdiction, family law is a little bit different. I did go to law school in Florida. So at a law school that actually did quite Florida-centric study. Oddly enough, I booked family law, which is to get the highest grade in the class, highest grade in the level. I never wanted to be a family law attorney. I kind of fell into it. Odd story. Kind of fell into family law. Kind of fell into the practice of stand-up law. For those of you who haven't heard this story before, welcome to the channel. You're going to hear this story. How did I become a practicing lawyer? How did I become a stand-up lawyer in court? How did I become a trial lawyer? Well, when I went to law school, the goal was that I was going to be they called them swivel chair lawyers and stand-up lawyers. I wanted to be a swivel chair lawyer. I wanted to be in my chair. I didn't want to be in court. I wanted to be a corporate counsel somewhere. That was the goal. That was the dream. But I graduated law school at a time when they were not hiring a lot of lawyers. They really weren't. So what did I do? I took a job. I moved back in with my folks, took a job at a law firm that required me to drive about an hour and 50 minutes to get there, hour and 50 minutes to get back. I got paid the whopping salary of $36,000 per year. Yes, as a licensed lawyer. And I was in court during my first week on the job. No partner there supervising in court. It was there for what I thought was an arraignment on a simple assault. It was not an arraignment. It was a trial. So my very first day in a courtroom, I actually had to try a case. Scared as hell. ended up, well, it was a disaster. It was a complete disaster. The guy was, I mean, as most criminal defendants are, the guy did the thing. And I made every wrong decision you could. The prosecutor in that case is now a buddy. The judge in that case, I then saw several years later after I'd been practicing for quite a while. It was trial by fire. It was absolutely trial by fire. Rob, what state was that in commute in? I was living in Maryland and commuting to Woodbridge, Virginia. Absolutely miserable commute. It was pretty awful. Could it be ineffective assistance of counsel? This was, so the other part about this was we have two different trial court levels in Virginia. We have general district court and circuit court. A lot of smaller crimes, smaller misdemeanor cases get brought in the general district court. And what ends up happening is if you get convicted in the general district court, you have an automatic right of appeal to the circuit court to have your case heard de novo, heard brand new. You get a brand new trial. So there was very little consequence to this because it was general district court proceeding. And it did get appealed up and it did get eventually resolved on the appellate level, not with me as the attorney. Client wasn't very happy. So it was absolutely miserable. But it put me into a courtroom pretty early on. And I hated it. I hated being in court. I hated the stress. I hated the anxiety until I got a case that I loved. And it was a case several years ago with a mom who was going through a really rough time. And during that rough time, she had essentially granted custody of her kids to her brother. And she had done a whole lot in her life to improve herself and get back in the position of doing that. And then she had petitioned because the brother had kind of cut off contact. The brother was alienating, or keeping the kids away from the mom. So probably about 6 months into me practicing law, I'm trying a case that's a 3-day trial on this issue of a mother trying to regain contact with her kids. And it was the first time when a case actually really mattered. It was one of those things where you don't really realize, a lot of lawyers, we do very good at masking. We kind of put on the mask in the presentation to the court. People look at us as being dry, emotionless individuals who can't really contemplate, because that's all they see. They see the mask. It's something that you learn. You don't have that automatically. I remember giving closing argument in this case, and I actually ended up tearing up. I haven't done it. I've done it maybe once or twice since then, but it was something that had hit home in a way that I couldn't mask it. I couldn't hide the emotion that I actually was experiencing at that time. Tried that case, reached an outcome. Wasn't what we wanted, but it did end up turning around about a year later. And then there was one additional case that actually made me really, really, really fall in love. And this one was in bankruptcy court. And I remember walking up federal court. So you walk in and the judge calls the case, walk up, go up to the podium. And there's a microphone there. It's the first courtroom I've been in with a microphone at the podium. And I didn't know what the hell to do with it because it's a microphone at the podium. So figure, okay, why not? Rob Morton for the debtor. And all of a sudden I hear the speakers in the ceilings and in the back of the courtroom, and it's my voice. And I was like, well, holy shit. That didn't expect. And I think I actually looked up. But I do remember Judge Kenny was on the bench, and I do remember there was a little bit of a smirk when I looked back down. And it was in that moment and getting comfortable with a judge that was kind of pushing back on an argument that I was making, but I loved the argument, where I actually felt comfortable, and I started arguing with the judge. And judge ends up taking the matter under advisement. A couple of days later, issues an opinion in my favor. I loved it. I was hooked. I was absolutely hooked. When I realized what this was, what this job entailed, and that you take the responsibility of someone who would not otherwise be capable of speaking or articulating their position to a court, and it's your job to stand up there and to be their shield, to be their sword, to go and make those arguments and have those fights. And to know the gravity of that, where someone literally takes the most important thing in their entire world and puts it into your hands and they say, I trust you, you do this, is really, really, really remarkable. Now, family law, how did I fall into that? Well, it's a percentage game. And when I graduated law school, there weren't a lot of lawyers out there. One thing that is always going to exist and does always exist is the existence of family law cases, domestic disputes. Whether it's a divorce case, whether it's a custody modification, whether it's child support, spousal support, property division, post-divorce enforcement, any number of things that arise, families are always going to be families, and families are always going to be complicated. And they're always going to resolve. When you have two people who have equal rights, father and mother, and their rights, neither person's rights stand superior to the other person, and they cannot agree on something, by very definition, it has to go in front of a third party, namely a judge. So you are always going to have those disputes. And I ended up being pretty good at it because I ended up the son of engineers who was essentially an artist at heart. I had the ability to speak with the client and really get an understanding of what it was that was important to them. And then I was able to turn around and translate that into something that was logical, coherent, and structured in terms of an argument, or to meticulously craft a direct or cross-examination to make my points while never losing sight of that emotional importance. And I loved it. I don't love the cases sometimes. Sometimes they're really ugly, not really pretty. And the way I've explained it to people is that people say they're in disaster recovery. I am too. I'm just in a different form of disaster recovery. My job is to help you, the client, get from point A to point B, meaning you are in this mess. We are going to get you to the other end of this with as much of your life as you can possibly have. We're going to get that door closed and get you on a fresh start. And that's the goal. And I've been doing it for 15 years, and I've enjoyed it, liked it. It gets messy because families are messy, but it needs to be resolved. You're dividing something that was never intended to be divided. You are dividing time with children when the intention was, in the minds of those children, they would never have to go from one house to another. They were going to live in one house their entire lives. They didn't make the decision to be between two houses. The parents did. Whether the decision was justified or not, the parents made that decision. And it is my job to make sure that horrible things don't happen as a consequence of that decision that was made by the adults. So I end up dealing with adult children all the time, and it gets very ugly, it gets very complicated, it gets very interesting. The other thing about family law is very fascinating is you actually end up dealing with just about everything. So give you an example. When I have to talk about my client's profession or their ability to earn an income or what they did on a daily basis, I have to know what that profession is. I have to know what's entailed in doing that job. I have to be able to articulate how the person gets compensated, how they would justify the compensation they receive. So I end up learning a lot about a lot of different professions. I end up learning about mortgages. I end up learning about taxes. I end up learning about additional fields of engineering, any number of things you can learn. It is actually very fascinating. And I joke that I hate math, but pretty good at it. I love it. So that is the long-winded story as to how I got to where I am and why I still do what I do. The number of lawyers that say I would never touch a family law case. I understand why they wouldn't. For me, the practice of law is about making sure there's the correct and just outcome, right? What's the fair outcome? And the practice of law is about preserving things that are important to individuals: life, liberty, happiness, property. You have civil cases where they're arguing disputes over land, or they're arguing dispute over certain property items. You have criminal cases where they're arguing over livelihood, whether someone did a crime or not. I get to argue about something that is perhaps the most important thing to people in their entire world, their family. And I get to fight for that family. And it's a really cool thing. So yeah, it gets ugly because people can get ugly. There's no one worse. There's no worse side of a person than someone who's in the middle of a family law dispute, in the middle of a contentious divorce, or in the middle of a custody dispute. You see the people at their worst. You see people at their best. You see people anywhere in between. So I cut a lot of slack. I give a lot of grace. I give that as a precursor to the Adelson discussion, because when we get into the discussion of this particular litigation, I'm probably going to say things that are going to upset people. But I'm going to try and give as much context as I can. Okay? That is what exists. Okay. Let's do this. It looks like we're kind of caught up. I did want to, I'll hold off on that. There. Robin, the ADR pro. This is why I love practicing law, Rob. There's so many things you learn about when you're doing your job. Yes, 100%. I love learning everything I can about someone's career, where they go to work, how they do their job. And in this area, Northern Virginia area, you get a lot of really cool stuff that a lot of people don't really get to know. It's kind of fun. It's very, very neat. A lot of you guys sending very nice sentiments. Thank you very, very much. It's all very kind of you to say that. I am probably, people who are listening to me now are probably very like, oh, that's very kind of you. But you still don't want to be across from me in a court. I'm a very different person as an advocate. I don't know if I can describe that properly. I get to share the human part with you guys. I get to laugh. I get to joke. I'm not actually performing my job of litigating a case. When I am litigating a case or when I represent a client, there are two parts of me. There is the attorney and there's the counselor. That's why I've always loved the phrase attorneys and counselors at law, because I always viewed the job as being two things. One, I am there as the counselor. I am there to advise you on what the best thing for you is. What is your best course of action? What should you do? How should you make the decision? What are the costs? What are the pros, cons? How are you supposed to weigh whether or not you agree to a compromise? So I'm supposed to lean very hard on my clients. I'm supposed to be understanding of their concerns. I'm supposed to take them beating up on me, yelling and screaming at me, even though I know that I'm not the target of their frustration. I just happen to be the person standing in the way. I'm supposed to help them make the best decision for them. Second part of that job, once they have made that decision of what it is they want, once they've made a decision of what is best for them, I'm supposed to fight for it. And that is whether I agree with what they said or what they desired or I don't. The relocation issue. Perfect example. Let's talk about a relocation. Let's say that one of my clients wants to relocate with the children. I will talk with them about the burdens in the relocation. I will talk to them about the consequence of them relocating if it's not granted by the court. I will talk to them about what they have to prove to do it. And oftentimes I'm trying to dissuade them, a lot of times trying to dissuade them from the decision they've made to relocate, because the decision is very rarely one that a court will view as being important enough to remove the children from the access that they otherwise had with the other parent. Sometimes the clients don't listen. At that point in time, they say, I'm going to relocate. Okay. Now I got to put on the other hat. Don't agree with your decision, but now I got to put on the other hat and argue why that decision should stand. It can be difficult. It can be frustrating. But again, that's the job. At the end of the day, it's the client's life, not mine. And I have to remember that. So, oh gosh. Jess Catlisi, puppy on the playground, pit bull in court. It's 50-50. I'm very different when it comes to cross-examination. I'm not necessarily always the most aggressive. I like to I like to get the person talking. Then I like to get aggressive after they get comfortable in talking. But thank you, Jess. Very kind of you. Ian, I see an avatar. How you doing? Well, I saw an avatar. Sana Burfoot. Today's my birthday, Rob. 41 years young. Love your channel. Sana, happy birthday. Happy 41st birthday. May you have many, many more. So cheers to you on your 40th. I hope you have a wonderful day, week, month, all of the above. Ian is trying to find his way in front of a camera and or microphone. Blessed in Texas. Love my online law buds. DJ Rob is the family man. I try to be family oriented. The other part about it is I love family. I talk about Bruno. Hope you and the Mischiefs are well. Mini Mischief number 2 started baseball this week.
Uh-oh.
He is 6. I don't know if you've ever seen what a baseball team full of 6-year-old boys looks like, or trying to keep them like corralled in one location for one purpose, to organize them.
I'm guessing it looks like chaos.
Chaos is an understatement. It is the understatement of the century. And the downside of this one is because we have limited field access, the practice, for everyone who's had children in the chat, the practice is 2 hours.
So it's got to be focused.
2 hours long. Getting a child to do something for 2 hours straight, impossible. Getting them to do it and maintain focus, composure, not have a meltdown, and not run into a screaming match with their other friends and go crazy and play games, tackle, hit each other with their helmets, impossible. I saw these boys put on their batting helmets, and all of a sudden the batting helmets turned into like they were rams hitting each other. They did that for a solid like 30 seconds before one of the parents saw them doing it, going, "Hey, nope, that's not a good idea. That's a hospital trip." And then the coach is like, "Let's do batting practice." And every single one of these boys runs to grab their baseball bat. And I was like, holy shit. Like, no. This is the worst idea ever. It was an experience. It was
I'm guessing there were still 0 fatalities though.
0 fatalities. Except my piece. My piece was a fatality. Oh,
well,
God. It was wild.
Your piece has pieced out, so.
Oh, I also learned that Mini Mischief 2, Mini 2, his friend on the team, one of his friends on the team, the friend's mom is an opposing attorney. I don't have any active cases against her now, but you
have and you will again.
I have and I will again. So this is going to make for a very, very interesting dynamic and experience. Yeah. So
you're like, you need to be the star player. You gotta beat out this person.
Oh, not necessarily. We're all at this age. The attorney on the other side is pretty good about leaving shop at the shop. Not bringing work home. So
okay, so you're all going to be chill.
We're going to be chill. It's going to be fun. Yeah. Oh, that is true. This is a very good point. Someone bloody random. Rob, it could be worse. She could be in chat right now. That is also true. She could be. I hope she's not. Oh, God. It's going to be funny. I see that RA is here. Scott, you're buying woodworking tools. Pray for my fingers. What tools are you buying? You are free to text me the answer to this if you need help, guidance, or if you feel like you're making a mistake. I trust your judgment here. But the statement of pray for my fingers is one that gives me a little bit of concern.
I was going to say, you trust his judgment as he notes that his fingers are about to get annihilated.
Yeah. I don't
that does not suggest good judgment.
Scott, just be careful. However, I will say that I have 100% of my injuries in the shop thus far, knock on wood, have come from hand tools and not power tools.
Remember, the safest tool in your shop, and so a good place to start is with a router.
Oh, and Elf Wiggins makes no, do not do the router. Don't do the router as your first tool. No, that's the worst idea ever, Ian.
That is Ian being mildly malicious. Don't listen to that.
I told you the story about someone that was going into like a woodcraft, and they were like, I want to buy my son his first tool, and they were looking at routers, and I was like, please don't do that. Like,
yeah, no,
please don't do that. And Elf Wiggins says, sounds like power tools, not chisels. Chisels have caused the most significant injuries to my person.
I mean, chisels are basically tiny little knives.
Sharper.
Yeah.
Sharper. Yeah.
I mean, if they're designed right, then they should be sharper.
Yeah. Yeah. Chisels. I had a buddy who damn near lost a finger to a chisel because he took one pass with a chisel without his hand behind the chisel. The rule with chisels, you always have your hand behind the chisel. Never put your hand in front of the chisel.
Yeah.
In any capacity.
Because the chisel doesn't like you.
No. And he made the mental glitch on one pass, and that's all it took. And he was in the hospital for you don't mess around with that. But
it's like, and yeah.
Oh, Scott, if you're looking for the basics. Oh yeah. Okay. We can work on this. Oh yeah.
Can I just say one thing?
Yeah.
You cannot go, oh yeah, in that particular tone of voice about woodworking tools.
That's false. Objectively false. I can
reserve that tone for mischief.
I can absolutely use that tone of voice in multiple settings. And
reserve that tone of voice for mischief.
I come on, Ian. Oh God. Okay, we'll hit two birds with one stone. Crazy Cat Queen, looking to buy a table saw. What brand is best? The best brand for table saw right now is SawStop. It just is. It is the most expensive brand, but it is the best brand. The reason why is it has the auto retracting blade, and especially for novice woodworkers, you do not want that hospital bill. So, Whoa.
That was my dad trying to call.
Oh, your audio switched over. Yeah, no worries. But yeah, SawStop actually now makes a contractor saw as well. So it's the best brand. If you got kids around, absolutely. If you yourself are a novice, absolutely. Save the money, spend the money. I also will say, don't feel like you have to start with the table saw. Start with the bandsaw. A lot less consequence, a lot easier to manage. And you can learn, you can get pretty straight cuts with it, especially if you combine that with a hand plane. So hand plane and a bandsaw will do you pretty well. If you really want a table saw, SawStop is great. Then you can work your way around that. So that's where and then just find a good hand tool set. Find a brand that you like and stick with that, purchase within that brand. Do not make it Ryobi. Don't do Ryobi. Spend the money on an actual decent brand, mostly because the warranty stuff is pretty damn good, and because they tend to stick with the same battery platform for longer periods of time. DeWalt, Milwaukee, those are your two, well, in my opinion, two best. Then you got Makita. Yeah. So buy a set within a certain brand of battery operated. Try to do as much as you can with handheld tools before going to a platform tool like a table saw or a bandsaw. Then go bandsaw first, table saw second, only if you need it. Don't need a drill press. That should be fine. There's the lesson on what you got to do.
Although a drill press is a pretty safe tool and they are pretty awesome.
No, they're awesome. They're just expensive.
You know what I recommend for a drill press?
Yeah, secondhand.
You'll find decent ones secondhand. And like my drill press, I got secondhand for I think it was like $75 that I spent on my drill press, and it is it's never given me any grief. It's fantastic, but I mean, decent brand from the day, Delta. So,
Yeah.
I previously had a really old table saw that my dad gave me, which was a better brand. It was a Rockwell Beaver.
Yeah, I
And
remember the Rockwells.
yeah, the old Rockwell Beavers were fantastic, but it was just real old, and so it lacked some of the some of the
shiny
modern
fancy parts.
conveniences. Yeah.
Yeah.
Like,
I've got a nice thin coat of rust on top of all the tabletops in my shop right now because the mini split unit in there went out. And it's not drying properly. So I've got some maintenance to do. It's
the
that's what it is.
the Delta, the feature that was like the big deal for me swapping over, is the fact that the Delta can change speed while it's running, which is a pretty basic feature, right? But it's a pretty basic feature, but it's also was not present in the other one. So, yep.
Oh my. Let's see. Where was this? Oh, Kristen. So I'm going to catch up on these. I'm going to switch over to the article. We can fill you in on the juror who testified, or the juror who gave the interview. Kristen M96. I knew my comment would be a conflict, namely that the purported burglar or the attempted burglar would seek to hire you as counsel after 3 years. I learned something from you, but trying to imagine Runkle's reaction if it happened, if they called you to be like, hey, can you represent me? Like, I'm the actual person trying to break into.
Yeah, sorry. There's a conflict of interest. I cannot help you. I actually, one of the things is there's like a lawyer's like Facebook group, and one of the things I posted there was like, good luck and no hard feelings to whoever takes the file of the guy who tried to break into my house. And yeah, people thought that was pretty funny because
Yeah, that would be pretty interesting. Liz McFall, your fierce advocacy and the fact that you are a different person in court is exactly what makes you effective and with a solid heart. It's very kind of you to say, Liz. Thank you very much for that.
I mean, you got to be a different person in court because, I mean, either you're not effective in court or you're like some sort of wang rod all the time.
Yeah, I call them Kool-Aid drinkers.
Yeah. You encounter that shit with like, family law sometimes where you get people who just like, you get it also with criminal law. Because like,
yeah.
I'm friends with a whole bunch of Crown prosecutors. And that's just kind of the expected way of life, right? You're going to make friends with people you work with. And it's not like, it's not like the Crown is like some rival enemy force, right? It's not like, there's Sauron or whatever from Lord of the Rings. So, yeah, I just, but you get people who sometimes, all Crown prosecutors are complicit. It's like, oh, fuck off.
Yeah. It's also, you don't want to burn bridges. So you try to maintain respect. Learn, try to get little boys to focus equals hurting cats. I have experience at hurting cats. I heard Ian all the time.
And cats are way more hurtable. Also, I heard that.
Lee Benoit, my family very much appreciated your insight and advice last year, and thankfully everything worked out in the best case scenario. Thank you for that. I'm glad that did. That's awesome. And thank you for letting me know. Music to my soul, stopping in during the Kansas City Chiefs halftime to say, I need your detailed reaction to George's cross at the second divorce attorney. I will. There's a page cut off for contentious divorces, right, Rob? We'll see. We'll get to that. Megan Easton, thanks for being a member. And Margot ran out first trial as a federal law clerk coming next week, finished the voir dire. So that means Texas. So, because that's Texas, the only place that pronounces it like that. So cool to be on the other side of the bench. Best job ever. Congratulations on the federal clerkship. That's really cool. You'll see a lot of cases. You know, when I made the comment about trying to learn and just absorbing everything around you, that job, you can learn so damn much. Also, cut the lawyers a little bit of slack. You haven't been in their shoes yet. I get frustrated when clerks are too much of a hard ass or too hard line, and they're just like, you can see when they're very judgy in some of their remarks, and you're like, all right, chill out up there. You haven't been back. You haven't been down on this side of the bench. So recognize it's a little harder to hurt your client and make sure you've got your client in the right position to go forward. Sandy, thank you for gifting memberships. Very kind of you. That is also probably a reminder from her to me to move to a topic. And I will take that reminder very kindly. Where was it? Joy Schmehar. Probably, I annihilated that name. I'm sorry. I'm experienced with tools, but I hit a knot in a piece of wood with a table saw and it kicked back. That's why I have a new table saw. I actually was on a little contractor saw. I was feeding a sheet of plywood and the fence actually got busted to the side, kicked it sideways, and the next thing I know is the piece of wood is in my chest and I'm on the ground. Yeah. That's why I say bandsaw is safer. Where was it? Broke the garage window. By the way, Runkle, my dad is from NB, Canada. New Brunswick? Is that New Brunswick?
That's New Brunswick.
Very cool. Camellia, for my membership anniversary and my 5-year wedding anniversary, congratulations on the 5-year. Total of 13 together. I'm excited for more family law stories. We're going to get there. We will get there. Okay, let's do this. We'll swoop and we'll go to the article because I want to talk about the juror reaction first. Okay, let's do this. Let's put this up on screen so we can see what we're doing. So we all know the end of the story. The end of the story, actually, let me see. Do I want to do this? Do I want to do this? I think I want to do this. We're going to start. We're going to begin with the close. Like Harry Potter, I begin at the close, or I open at the close. That is my brain just rambling as I'm trying to find a spot in a video.
Rob, can I make a request?
Yes.
Please do not cover the defense close.
No, I'm not doing that. I don't want to get yelled at for the next hour and a half.
The defense close is just god awful.
I did not understand what was happening or why.
I mean, some decisions were made in that close.
There were moments that actually made sense.
Yeah, but it seemed like it was by accident.
Yeah.
Right.
But here we're gonna start with the end. And we're gonna start with the end because it's just gonna be like, here, why are we talking about this? Oh my gosh, we're talking about a jury verdict already. We didn't talk about what the verdict was. Oh my gosh. Okay, we get the verdict. So all of a sudden, court's back in session.
Let's get you
time and review the verdict form. It is in its proper order. At this time, I will publish the verdict.
Before we get into that, favorite judge. Love this judge. Want to be in front of this judge all the time. Feel like I would vibe with this judge. He and I would probably disagree sometimes, and we'd probably get in a little bit of back and forth, being kind of stern with one another.
That would be the worst thing to ever happen to me because he'd be like, Mr. Runkle, quit your bullshit. But he's such a great judge.
Yeah, I love the demeanor.
We, the jury, find as follows as the count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
So I did see online some people were yeah.
If she was capable of controlling herself and behaving in an appropriate fashion, she'd be sitting in a different room right now.
Yeah, I think so. some people were criticizing the judge for making the comment of telling Ms. Adelson to control herself. And
No.
I am with you on this one. I wanted to clarify why the judge was saying that. For several reasons, the judge is saying that. One, it is expected of every single person in the courtroom to maintain composure and not have an outburst during the rendering or reading of any verdict, whether it's positive or negative. Doesn't matter.
Yeah.
Two, because it is actually not out of respect for the judge, it's out of respect for the jury. A jury of your peers just sat in judgment and listened to all of the evidence in your case. That jury was tasked with probably the hardest job that you could ever imagine, which is to determine the guilt or innocence of a person in front of them, and the consequence, even though they're not supposed to know that, the consequence, we'll see what I'll replay the outburst so people can see it. Hang on. Let's do this.
The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count two. We, the jury, find as follows as the count two of the indictment: conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count three. We, the jury, find as follows as the count three of the indictment: solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. One moment. Members of the jury, the bailiff will escort you to the jury room.
The other thing is that the verdict isn't actually final at this point.
Yeah, there's this, which is why the jury gets sent out. Because then the judge is like, we have to do some work here to make this final.
Yep, the jury can still be told, and if one of the jurors says, no, that's not my verdict, then they got to go back in the room, and maybe a mistrial, maybe, all sorts of problems. So her, if the purpose of her outburst is a sympathy play, it could potentially spoil the verdict, right? So,
it's not even the sympathy play. So let's let him speak. He sends the jury out, and he actually comes as the admonishment right there. Magical Mary, this is the most accurate. It's an adult temper tantrum.
Mrs. Adelson, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you will be removed from the remainder of this process.
If you cannot control yourself, we will control you.
Do you understand what I'm saying to you? Yes. Do you need a moment to collect yourself? Before the jurors are brought back in, we will take a brief 2-minute break. Please give her tissues if she needs them.
Okay. Now that she's off the screen, we actually know what the conclusion was. Let's explain some of the back and forth and why the judge did the right thing. The jury heard all the evidence. They heard your argument. They heard everything that you had presented. It was hard enough for them to reach the decision they did. It was hard enough for them to get to the consequence that they knew, even though they're not supposed to consider the implications of a guilty verdict and what it might mean as far as your sentence is concerned. They damn well know. If they're convicting you of murder, they know it's going to be a long sentence. It ain't easy for them to get there. And they know.
Also, they can look at her, right?
Yeah.
You could just look over at her. And even if you are so deluded as a juror to think, this won't be more than 10 years, where 10 years leads her.
Yeah. So it was hard enough for the jury to make that decision. And I don't mean like weighing the evidence was hard. There is an emotional impact to making a decision that is going to put someone into jail for the rest of their life. And it wasn't easy for them to get there. They made their decision. You don't get to make an attempt at essentially shaming them or guilt tripping them or having that emotional outburst to make them double guess their decision. They made their decision. That's what it is. It's their verdict. That's their outcome. So you are to respect that decision. I don't mean to say take it like an adult, but yeah, take it like an adult. And the judge is there to protect the jury. The judge is there to administer the courtroom, but the jury was the finder of fact. The jury heard all the evidence. The judge marshaled what evidence came before the jury, but the jury is under the judge's protection. So if the judge sees you pulling some shit with the jury, the judge is going to do what he has to do to protect the jury. And that includes excusing the jury and telling you that you have to be an adult, compose yourself, and understand that there's still more work to be done. So I had no problem with that.
Adelson, get your poop grouped.
Yep. Get your shit together. So it is a fair point. To be fair, a 70-year habit of emotional manipulation is hard to break. It was pretty wild. I'm not sure. I saw a lot. I did watch the victim impact statements. I thought they were impactful.
I thought they were excellent.
They were.
I can say I've rarely seen a victim impact statement as cutting and honest, and yet free of because a lot of victim impact statements are somebody screaming at them, basically going "I hope you die. I hope you." What was that trial recently where people were going "I hope you get
the Coburn case
in prison," that kind of thing. Yeah, and I was like, that's not cool. That shouldn't be happening. But
was it Phil who said my favorite part, which was in the Jewish faith, we have the tradition of wishing someone 120 years of life.
Yeah.
May you live for 120 years. And he just goes, Donna, may you live for 120 years. I was like, that is just chef's kiss. It was perfect.
That wasn't even my favorite part.
I just thought it was perfect. The family destroyer part?
My favorite part was just his finishing thing. He's like, I have one question for you.
Was it worth it?
And then and you can see she just because everyone she, says she cared about is destroyed.
Was he the one that went through the fact that the kids don't have he was
yeah,
okay, where he was going through and say these children don't have a father to grow up around them, they were deprived of their grandmother, he went through the deprivation of all the different people in these kids' lives, children now growing up without parents, families that have been destroyed. For me, that part right there, that is what a victim impact statement is supposed to be. It is supposed to articulate the true consequence of the decisions made by the defendant.
Yep. 100%.
It was beautifully said. It was absolutely everything that needed to be had. So let's do this one a quick swoop. Because now I wanted to see the verdict, play that real quick. Oh, Nick came in. As I told Ian, if it weren't for the facts of the case, the defense closing was good. Fiery and passionate, but a bit late for sleeping pill beauty to wake up by then. I hated the pounding of the podium.
It was not a good close, even if the statement, or even if things were on her side, which they weren't. But the thing is that it comes off as lecturing. It comes off as preachy. It comes off
hated
as
my client. I hated the my client references every fucking time. She is Donna. You say Donna.
Or if and the thing is, some judges will give you shit if you say Donna.
Mrs. Adelson.
At which point your client is Mrs. Adelson.
Yes.
And you know what? In her case, I'd probably go with Mrs. Adelson.
I would too, to reinforce the age. Yeah.
Because Mrs. Adelson sounds like a kindly old grandmother. Donna sounds like, the woman who's at your bridge club.
Yeah.
So I would go with, Mrs. Adelson. Just, kind of emphasize the kindly old grandmother approach that you're trying to go with. And, And don't yell at the jury. Jurors hate being yelled at. You know,
Well, it was, and the other thing is, here's,
well, and he had lines like, if you believe this, then you have not been like, then you have not paid
it was
attention to the
so,
evidence. And I'm like,
which is so dumb. It is so dumb. So dumb. You don't fight the jury. You bring them into the fold. One of the best tricks in any closing. So Nick, here's, I'll pull the comment down and we'll continue talking, but here's the point where I will agree with you. The fire and passion, I will agree that I was surprised to see that come out. I didn't see that before. I wish I would have seen that during trial at some stages.
I can tell you the tonal approach I would have taken on that.
In this closing?
Not the fire and brimstone. I wouldn't have gone fire and brimstone.
No, I liked the volume would have been good to get their attention at the outset, but you don't maintain that level of volume. You hit it for certain points, and then you drop back down into a lull.
I would have gone with, ladies and gentlemen of the jury, we have juries in this country for a very important reason. We have determined over years in this country that jurors are the best finders of the truth.
Yep.
That jurors are the thing that protects people from the state where they are innocent. And I am here to ask you, I know you will do the right thing. I know you are here to be diligent. I am just here to ask you to do your duty and to present to you information that I think will help you in ultimately reaching the correct decision to acquit Donna Adelson of all charges. Let's begin by covering, and then wherever you want to start in terms of the evidence.
You know what else I like to do?
You tell the jury you're on the same team. Like we're team, we're team find the truth.
Here's one of the things that I like. I like taking the approach of, one, you bring them in. So when you make a comment about what they observed in the trial, you don't say, if you were paying attention, you don't say that. You say, we all saw this. We saw it.
Yeah.
We saw this happen. You embrace them. You are a collective we. You are never us, them. It is we. We saw this. Or if you're saying that you saw this, you're saying that you saw this during the trial, and you highlight their ability to perceive the things that you know, because you have to believe it. You have to know that they saw it. But the approach that I like to take,
I saw this, and I know you did too.
Yes, exactly. And I
then
think
if
that
they didn't see it, then they're still going, yes, I did, because of course they will. If she was so bad. Why is she so bad?
Another one of the things that I like to do, strategy wise, one of the things I like to do is, and I do it because I don't present in front of juries. I'm presenting in front of a judge. So usually a judge is a hot bench. So what I do is I try to predict what the judge's questions are, and I begin there. And I say, Judge, here's what I'm going to do. I can go through the steps 1, 2, 3, 4, 5, but I'm going to go in that order, but I'm also going to stop at certain points where I feel like you might have some questions. So you look at the jury, you said, jury, you've been here for a while, and you heard the prosecution get up and stand up, and you heard them deliver their closing argument for why they believe you should find my client guilty. And I know that throughout the proceedings and throughout this trial, there was evidence that was at times long-winded, at times a little bit difficult to sit through the entire time, at times emotionally impactful. So I'm going to try to anticipate.
I thank you for
doing it.
I mean,
and then I'm going to try to anticipate the areas where you might have questions. And if you don't have a question, that's fine. But if some of you do have a question, I'm going to try to anticipate it. I'm going to try to explain or give you the answer to the question based on the evidence that we heard at trial. So you get ahead of them. You can say, I imagine some of you are probably wondering why this letter or why this, what was the script? Call whatever the fuck you want to call it. But some of you have this question of why that exists. How did the state present it this way? So you get the jury on board with asking the question. And they're like, yeah, I was fucking wondering that. And then you're like, okay, cool. Let me explain my side of it. I love that.
She came in knowing what the jury was going to do. She starts her thing knowing that the jury is going to convict.
Yeah.
And she through her language, she
Scolding
basically
them.
tells the jury that she knows this,
She was scolding
but
them.
she's scolding them for doing it.
Yeah.
You are about to convict my client and fuck you. Well, they're like, okay, well now I don't even feel bad about it, right?
You're not wrong. That's
I'm
how it
just an
got, that's
asshole.
how it was perceived. It was a lot. Nick, maybe it was extremely low and I think you're more in line with this. It was extremely low expectations, but I liked it. I will say I liked a bit of the fire. I was happy to see that she finally woke up, because what we saw before was a whole lot of blasé and not a whole lot of emotion. So
The
I did
fire
like
was
the
the
emotion.
wrong
I just think
approach.
it was just misplaced a little bit.
This was the wrong time for fire, right?
Yeah, it was a lot
It's
of
like-
fire too.
It's like she finally figures out that fire would be helpful when she's at home and she's like, I'm going to burn my house down now.
Well, and Joy asked
And,
the question. I want to know, have you ever seen a defense in closing defending themselves? In my life, I've never seen anything like that. You're right.
And that's the thing. She had hurt feelings.
Yeah.
And it was clear. And she told the jury she had hurt feelings.
Uh-huh.
And I'm like, why are you going in and telling the jury that you are upset by this?
You know what it reminded me of? The Murdoch closing for the defense.
Yeah. It's just, this is what happens if you're like too into your own shit, where you don't realize that you're, like your client is getting convicted and this isn't about you, right? It's not your failing. It's not your whatever. But you still give it your best shot, and your best shot cannot be your own hurt feelings.
Nope.
There's just no place for that. And so long as she was there with her hurt feelings, there was no way for her to win. Like, I get you're upset. I get you're pissed off.
Yeah.
Yeah.
Sandy, thank you for the 3,000 that are here. Please hit the like button. Yes, 3,000 of you are here. Welcome in. Sit down. Have a seat. Grab a cocktail. Grab some popcorn. But please hit the like button when you're there. It takes 2 seconds. Like, subscribe. Very easy. Very, very easy. All right, let's do this. I'm pulling up the article. Tallahassee Democrat. Juror tells all. Jury foreperson in Donna Adelson trial speaks out after conviction. This was published this evening. Not even 24 hours after Donna Adelson was read her guilty verdict, a woman on the 12-person jury took to TikTok to dish about her time in the courtroom. They were tasked with weighing Adelson's innocence or guilt in the 2014 murder for hire that killed Dan Markell. Ultimately, they found alleged Adelson guilty as charged. She's the 5th person to be charged in the infamous murder of Markell. A law professor at Florida State University, the 75-year-old was convicted of first-degree murder, conspiracy, and solicitation.
That's solicitation to commit murder, not the other kind.
Not that other kind. Yeah. Not the other kind. So the jury foreperson said she led the deliberations and delivered the unanimous verdict to the matriarch mastermind. Now that the trial is over, I'm free to talk about this. My mind is just absolutely blown. If you have questions, let me know, because I can finally talk. So the Tallahassee Democrat actually confirmed her position on the jury through court records and visual identification. Yeah, look at this. Look at this. A newspaper that's confirming their sources. My word, what is this? This is amazing.
They're doing journalism.
Oh my gosh. Wow, they vetted their sources before they ran the article. This is the Tallahassee Democrat. Way to go. I hate that I have to say that, but my God, way to go.
Oh, we've seen some dumb shit lately.
Oh, we really have. We really, really, really have. What evidence convinced you or surprised you? Answer. Honestly, there was so much. She's a smart woman, which is why she avoided being convicted for 11 years. I'll answer vaguely, but I may need to do a separate video talking about this if enough people are interested. Oh, there's a lot of interesting.
Oh, yeah.
Rob's testimony was pretty telling. Oh, yeah. Which is which makes
Which
you
is exactly why they didn't want him, like the defense didn't want him testifying and tried to
yeah, and
limit his testimony as much as possible.
it's kind of why attacking Rob Adelson was a bad move during the close.
Yeah. Well, I
Oh,
mean, it's just destructive, right?
2, all the code was very telling. No shit. Like,
Yeah.
3, all of her emails, text calls indicate how power hungry she was. She meant it when she said that Dan Markel wasn't going to beat the Adelson family. Yeah.
Ooh.
4, the script. Oh, the script for Drina if she were to be a witness for Donna, and the script for Wendy that she wanted her to testify on Charlie's trial. 5, the extortion story is very clearly bullshit. 6, as the foreperson, the final point I brought up that cleared up some confusion for the other jurors was the wiretap video of Charlie and Catherine at Dolce Vita, specifically the part towards the beginning when Charlie said, "My mom hasn't told my dad anything." Yeah, he would lose it. Or whatever he said exactly. He wasn't talking about the bump. It was about the murder. There's no denying that. Yep. Oh.
And this is why we have juries, is because they're actually
Really good.
super smart.
Yeah, I always blame the lawyers for not getting the information in front of the jury. You don't blame the jury, you blame the lawyer for not getting the information in front of him when the jury makes the wrong call.
I mean, the thing is sometimes juries do dumb, weird jury things. But on balance, juries actually do a pretty good job. And sometimes I think juries do a better job than judges would. And like, I'll give the example of self-defense cases. Somebody, and this is like a big thing in Canada right now, because did you hear about the crossbow case?
No.
Some guy stabbed a guy who was in his house, but the guy who was in his house was armed with a crossbow.
Okay, I thought you were going to say you can't stab with a crossbow, but armed with a crossbow and he got close enough to stab a guy? Crossbow is a range weapon.
Well, it sounds like the guy with the crossbow took a shot and missed. And this is like, a lot of this is rumor, right? And then got into a fight where he was using the crossbow as a bludgeon and got stabbed, right? So bringing a crossbow to a knife fight is a great idea so long as you can make that first shot. Because if you can't make that first shot, then now you have the lesser weapon in this conflict. But they arrested and charged the homeowner, and
really?
like people are. But here's the thing: is that if you are a judge, you have like security, and your house gets registered in like a system such that if you if you call the police actually can see
we
that
have
you're
that
a
here
judge,
too. Yeah, we have that here
and they
too.
know to respond real fast, right?
Yeah. Get your ass there. It's yeah.
So I mean, they're not responding to the same speed at of Judge so and so versus like
You mean like the testimony of the Karen Reed trial? I expect that they respond the same amount of time for an officer down as anybody else.
Yeah, bullshit. And he knows that's bullshit because they have different codes for officer down versus anyone else down. They have a code for that.
Yeah, the judge. Got it. Judge.
But judges are so far removed from that fear, from that terror of somebody kicking in your door late at night, that it just like that they're not good decision makers on this particular issue. And they're like, well, why didn't you like do whatever? It's like, because they're fucking terrified, dude.
Yeah.
And we expect them to be terrified. And, the Canadian law says your actions have to be reasonable. And the thing is I'm a pretty reasonable guy most times. If you want to get me to be unreasonable, you'd have to do something crazy, like break into my house and attack me, right? So, the problem that we get is judges don't get it. They don't, they're a poor judge of what it is to be like scared shitless like that. And so in those cases, I think that like a jury will make better decisions about the outcome than a judge will.
So, question: do we want to watch? Just briefly, do we want to watch the? Because it looks like I have the video where it looks like she actually does the like a Q&A.
Oh, I want to watch that.
You want to watch that?
I mean,
Okay.
I can't. I'm futzing around trying to get ready for 3 Gun tomorrow, so I'm not
All right,
watching.
but you can hear it.
I
right?
can hear it.
So if I play it, all right. Let me do this.
And I totally do want to hear because
Yeah,
that
let's do this. Let me boost this. I'm gonna boost this audio a bit. And share this tab instead. Okay. Let me see if I can't. Yes. No, wait, no.
But I do want to preface, okay? For one, not a single member on the jury knew anything about this case before.
Why is it going so fast? Why are you going so fast? You're not sure. Are you going for normal speed? Your normal speed.
sometimes the TikTok thing is that people speed things up in their own videos.
Oh, okay. So this is the initial post that she made, and then the Tallahassee Democrat goes and verifies who she is.
Found guilty on all 3 charges for killing her ex-son-in-law. I'm here to say that I was on the jury and I got to be the foreperson. If you have questions, let me know because I can finally talk.
So, cheers to her for that. I can finally talk. Like she was probably going nuts the entire time.
Oh, 100%. You can hear that in her voice there.
Yeah. All right. So I've got the audio boosted. Hopefully it's enough. I'll go ahead and try to boost it some more. Need to do the boost. Booster
Booster juice.
Booster juice. Boost. That one. There. Okay.
So I'm going to answer some questions now. But I do want to preface, okay? For one, not a single member on the jury knew anything about this case before.
Ma'am, I apologize, but you said preface, and I can't not hear that. You said preface. Thank you for answering our questions. Thank you very much for answering our questions. Can we do preface next time? Just thank you for answering our questions.
Being selected to serve on the jury, okay? First and foremost. Number 2, as far as people's concerns as to me being on social media and posting my TikToks in the last week or 2, there was no rule stating that we cannot be on social media. The rule was provided by Judge Everett in this case, okay? We cannot seek out information about this case. We cannot talk about the case with anyone. We cannot listen to others talk about the case. We cannot do anything in regard to the case during the trial. But now that I'm released as a juror, I have the freedom to say and do whatever. But also in that regard, I don't watch the news. It's depressing. I haven't watched the news in years. If anything,
Same girl. Just same.
I'll check my weather app, my little Apple weather app once a week just to see. My For You page on my TikTok, where I am the most active, is mostly like TikTok shop videos, like members of like the moms of TikTok community, because that is the content that I typically engage and interact with. I also post that type of content sometimes, just like trendy, funny, like music videos, whatever else like that. Basically like stupid humor and then mom stuff. That's what I look for on social media. So I'm not breaking any rules. Along with that, I have time before court during our 1 hour, at least minimum, lunch break during the days of the trial, and then after court to do as I will in regard to all of that. So no rules were broken. No rules are being broken now. I appreciate all of your guys' concern.
She
Also like to
100%
prove that I
was
was
able
on
to
the
do like,
jury because there's some of you.
Yeah, go ahead.
if she wanted to do like TikTok dance videos,
I don't give a shit.
she's totally allowed.
Yeah, I don't
like-
care. And
Well,
if she's scrolling TikTok, as long as she like if she hits an Adelson thing and just flips past it, I don't care. And I actually trust that people do that.
Yeah, it's 100%, within the rules, and no social media would probably actually violate, First Amendment.
Oh wow, who let her on the jury? Northwest. She has kids the same age as Danny's were when he was killed.
Oof.
That should have been a peremptory.
I mean, I'm guessing that they probably ran out of peremptories. There's a lot of,
Yeah, I guess.
there's a lot of potential issues on this one.
Yeah.
Here is my appreciation letter from Mr. Stephen Everett, the judge on this case, thanking me for my service. Along with that,
That
my
is super classy.
document stating I served in the jury every single day of the trial.
That is.
Also this lovely thing called public record.
If I ever become a judge, I'm totally doing that for every juror.
I also like the fact that she probably got trolled by haters and she's like, fuck you guys. Yeah, here's the proof.
Yeah.
Now with that,
Let's see.
I will get into some of these questions, okay?
All right.
I am excited. I learned so much and like about the case, but also about the law. And I like that excites me. That I thought it was a cool experience. A crazy first time jury experience. So yeah. Anyway, I stated I
Of
was
all
the
the trials
foreperson,
to be your
and I
first
was.
trial.
Seriously.
Because when we got back to deliberate, once the bailiffs were out of the room and we could, talk about whatever, I asked anyone. I asked everyone if anyone wanted to be the foreperson, and everyone was kind of like, I was like, okay, can I do it? Like, can I please? Also, because I wanted to stay on point with what we were supposed to do. You know what I mean? Like, I didn't want someone else to have the opportunity to be foreperson and then just take us a million different directions. And I know how my brain works.
I am feeling called out.
Like very.
She was afraid there would be a Robert Ian on the jury. And she was like, we need to be organized, and I'm gonna do that, and I'm gonna be organized, and I'm gonna make sure we're moving along. And I'm like, shit,
She's like,
that's too much.
She's like,
That's too much
Russell, I'm
executive
calling
function.
you out.
I love the I wanted to be foreperson because I have a question. I got a jury summons, a jury questionnaire, and I have the ability to check the box that says I'm a practicing attorney and I want to be opted out. But
you didn't.
I can show up if I want to. And there's enough new judges on the bench that I might do that. I don't know. I haven't decided yet. But yeah, and then I told my associates this and they were like, could you imagine if Rob got chosen on the jury? I said, hey, what the hell do you mean by that? Because they said every juror would hate him. I was like, what do you mean they would hate me? Because you nitpick every single, it's the job. That's what you have to do. So they were ragging on me about that. I was like, fine, I'm going to do it. All right. Let's keep going. Questions.
Sequential and purposeful with my questions and discussions and what we talked about, whatever. So overall, it took us about just over 3 hours to deliberate and reach our final verdict, right? But within the first hour and a half, I want to say, everyone was agreeing that she is guilty. Everyone, it was unanimous within the first hour and a half. But as the foreperson,
somebody had Taco Bell
looking for, the different body language, people's facial expressions, all of that, just who may be unsure of something. And we had that. We had 2 people who said they thought she was guilty. They're like, but I'm kind of confused on this one thing, this like 0.2 on count 2 of her charge, right? So with that, I was like, okay, absolutely not. We are not unanimous right now. So we're going to go over things. and we went over things point by point. Okay.
She's actually
We
probably
started-
wrong here.
Yeah.
Ah,
If they did a straw poll and they voted unanimous, that's unanimous.
yeah, it's like everyone's ready to convict. You don't need to make sure that they are like, you know, but she's like, I am Mama Bear. No one's going to feel bad about this later.
Funny. She really was though. She's like, everyone was like, no, she's guilty. And then she's like, but are we sure? And then like went around the room again, is like, but I can see in your eyes that you might not be sure. So let's do this one step at a time. I don't hate it.
I don't hate it, but it was unnecessary. And like, she absolutely could have been like, okay, everyone's sure. Yep. All right. Send out the verdict. We'll get a verdict in the first 20 minutes. And, you know,
Although you were close on the Taco Bell prediction. Like they were done within the first hour. It wasn't that someone had Taco Bell and was in the shitter. It was that they wanted to make sure. And I like that. I appreciate that.
I was just like, because I mean, normally I watch a trial and I'm like, you know, there's some questions and so forth. This one was pretty hard to get to anything else on. And the thing is, I could see a path to reasonable doubt on this one.
There was.
If Donna hadn't done all of the things to try to avoid consequences. Because what really permanently screws her on this is, hey, you know, I'm going to Vietnam. I'm doing the script shit, right? Like, if she hadn't done the script in the Vietnam trip, you could make an argument here.
Yeah, that's possible.
I don't get it.
Count one. Count one was the
So-
charge for first-degree murder, and it had several different points that we needed to, you know, address. We went over definitions, we went over principle and how that would apply, all of the different things. We listed out, we had a whiteboard in there, and
wow.
most of us are visual people, and so we used the whiteboard to go over each point, list out everything that like people just said that like applied and whatever. Those people who seemed a little unsure at first, they ultimately, what was needed, they needed the visual. But we went over everything several times because this is a big decision and this is serious, and we all took our duty very seriously. Like, this isn't just fun and games and like, you know. Although it is a very cool experience to talk about now and it's exciting, it is someone's life, you know, and it is the law, and we all took it very serious. So, like, you know, I need people to understand that. We went over everything, talked about everything over and over. In about the 3-hour mark, you know, once we were like, you know, moving and grooving, you know, we voted several different times in several different ways.
Okay.
I first had everyone, we went like by each count, right? So I had everyone go one at a time in order of our juror numbers. So 1 through 12. I was like, okay, so for count one, point, you know, like whatever, count one in general, is she guilty or not guilty? And I had everyone go one at a time. We all agreed guilty. After that, we did like an all at once vote. And I was like, okay, so for count one, like, raise your hand if you think she's guilty. We all raised our hands, but, you know, it's still doing our duty as we're supposed to. Went over it
At
again.
this
And
point, you're
so,
just killing time.
you know, people were still talking, just like, you know, they're sharing their thoughts with each other about the case and whatever. I was passing out 12 pieces of paper for everyone to write their final verdict down. And then I emptied like one of the little containers we had for our snacks and had everyone put it in there. And I did this because I wanted people to, and I said this too, if anyone who's on the jury with me sees this, they know that I did this. I told people, I want you to be 100,000, 50 billion% sure of your verdict. So I want people to write down what they honestly feel and think based on the evidence and the law provided. And without feeling pressured to go along with what everyone else is saying, this is how we can be sure that everyone's on the same page. So write down your final verdicts. We'll go over it. All
I
12
would have just
pieces
been
of
like, I am
papers
so
said
done with
guilty.
this.
And before,
I'm watching the chat while this is going on. You guys realize that our like a jury of your peers is made up of any number of people. Like when they say your peers, they mean everybody. They mean the old curmudgeon that's next door, or the neighbor. They mean the neighbor with the yappy dogs. They mean everybody. They're all jurors. And they're allowed to be, not just they're allowed. They're a part of this process. They're the ones that are sitting and presiding and listening to the facts. They're the ones that get to make the decision. They're the ones that get to judge the bullshit from the non-bullshit. And you actually want a disparity. You want a pretty vast swath of the population. Like you want young, you want old, you want everybody to be there. And you recognize that there's going to be some people who are going to be younger, who are going to be Gen Z, who are going to talk like this, and they're going to have this system, and they're going to be really excited. And there's probably going to be someone there who's never seen TikTok in their entire world. They're probably like, I don't get this TikTok thing. I don't like the TikTok. It's going to be everybody. Point is, getting 12 people to reach the same decision ain't an easy thing to do. 12 people all voting, 12 people all deciding that the facts were sufficient to prove beyond a reasonable doubt that these elements were met. So the personal attacks, stop. Cut it out. Love to see what you would be like. Absolutely would love to see what every single one of you guys would be like sitting on a jury, weighing someone's guilt, someone's innocence.
I'd
And
be
then
sitting
after
there
the
like,
fact,
can we just get in there and be done? We all
Yeah.
think guilty. Like,
Yeah. And then after
I'm
the fact,
good. We good.
after the fact, you come out of that jury room and holy shit, it's not just a little bit of media. It's the front page on every newspaper article. It's all over your live feed. It's everywhere. Imagine how you process that. You've been sitting in this courtroom for the past 2.5 weeks, and you walk out of that courtroom having made a decision, having heard all the facts, and it's like, oh my God. Yeah, I would absolutely imagine that people would react one way or the other. I imagine you would have some hermits who would go and hide from it, but I imagine you'd have a fair number of people who would be really, really excited at the fact that they were there. They saw it. Their job was important. And I want people to feel like their job's important. I want jurors to feel like their damn job is important. I absolutely want people to be excited about serving on a jury and hearing evidence. So I don't judge this one way or the other. It's a whole lot of Gen Z, which is just it's difficult for me, but hell, that's who makes up society. Someday if anyone gets charged with a crime, you're going to have a Gen Zer on your jury. So
You may or may not, but juries tend overall to skew old.
Old or super young.
Usually old.
It's old. It's people that have the ability to take the time off without significant consequence.
Yeah, it's the thing is that university students have consequence, so they typically get found. People with jobs, like if you're working retail, you probably don't have a job that provides for jury duty time, and you're probably not sufficiently financially rolling in it that you can just whatever. So usually what you see is like older people and a skew towards people who are in like government jobs and big corporate jobs, because they're the people who who have like clauses in their work agreements saying things like, if you're on jury duty, we keep paying you.
Yeah, I mean, it is, and I get the point that people are saying no one wants to have a jury go back, take a poll, and all of a sudden within an hour you're getting a verdict. But
I wouldn't mind.
sometimes that's how it happens. They don't necessarily, if they heard 10 days of solid evidence and they heard like 24 hours of bullshit, and their bullshit meters are all pretty much tuned in, do you think it takes them a lot of time? Do you think they have to go in and discuss a lot of the evidence? Sometimes the judgment, sometimes the decision is easy, sometimes it's hard. It varies. It seems like this was, they took it kind of methodical. Let's listen to the end of it.
I filled out the final verdict form that we had to fill out. We did one more vote. And I went around and everyone needed to tell me out loud and to each other that they found her guilty on all 3 accounts. And that's what we did. And then, filled out the verdict form, signed and dated it, knocked for the bailiffs to let them know that we were ready once they got set up in the courtroom. We went out there. Judge asked the foreperson to stand. That was me. I didn't show the jurors, but it was me. And I signed the verdict form, which I believe will be public record. But anyway, after that, he read the, what do you call it, published the verdict. And then, there was that outburst that we all saw. And we had to go back to the jury room. And when we came out, because the parties said that they wanted, Judge Everett went one by one, once again, with all of the jurors, and wanted to hear us say under oath that we find her guilty. And that is what happened. It was such a wild experience. Oh my gosh. I can't wait.
Interesting. Okay. All right. I don't hate it. I don't hate that. And I'm seeing people like saying, I wouldn't want them on my jury. You don't really have a choice. You really don't.
You don't.
You don't. These are your peers. These are the people that are sitting in judgment. This is what happens.
Technically, the judge is the one sitting in judgment.
Yeah, technically, yeah.
Not really, but
hang on. There's a part 2. Damn it, there's a part 2. Y'all didn't tell me there's a part 2. Do you think Wendy was involved? Oh shit. Okay.
Also probably along at the same time. Yes. Yes, I do. And do I think she is next? Do I think Harvey might be next? Absolutely, I do. Now.
All right. Someone didn't like the way Wendy testified. That's what that sounds like to me.
I don't think Harvey's going to be next.
I don't think Harvey's next. I think Wendy might be.
Wendy, it looked like a lot of that was a wind up against Wendy. I don't see it as Harvey's going to get busted on this.
Yeah.
The state hasn't said that specifically, but there's evidence showing that they were aware of what happened. And I mean, I had to think back and take my notes because, write down new notes. We couldn't take the notes that we took during the trial out of that jury room. They get disposed after deliberations. Minor details. Now, if and when the state goes after Wendy, I think they will. I think it's going to be to a lesser degree. It's not going to be the same charges, only because she insulated herself from her family, from the situation very, very well. Very.
All right. The volume is really low. It's really low. So I don't know if I can do it this way because I have it boosted 600% on the back end. But from what I am seeing, this is where the article picks up in part 2. So we can do the article because this is the question and answer part. And the part that I was fascinated with was, somehow Ian dropped off. I don't know why, but he did. They hear anything about the case beforehand? Not a single member of the jury knew anything about this case before we selected to serve. Did the jury find divorce lawyer Linda Bailey's testimony offensive? She denied the contentiousness of the Adelson-Markell divorce. Oh, this is where the young juror might be difficult. Interesting. Yes, I believe all of us had something to say about that. The way she kept avoiding answering the questions from Georgia, Kaplan, the prosecutor, really ticked me off. Like, oh, 80,000 isn't a lot. To who? You, the one who's a super lawyer and has been for the last 37 years, Miss Ma'am? Oh, baby, they had opinions. Holy shit. All right. That is, then there's, do you think when he's involved, part of the some way, shape, or form? How the jury come to such a quick decision? We went over everything several times because it's a big decision, very serious, took her duty very seriously. Like, this isn't just fun and games. It's someone's life and it's the law. And we all took it very seriously. I don't really care about the Wendy thing because Wendy wasn't the one on trial. But apparently a lot of people are very interested in that. See, she was a part of it in some way. She performed. She insulated herself from the co-conspirators way too well. She plays dumb so well. Oh, they picked up on her evasive answering. Looking at evidence, testimony from her brother, Rob, and her ex-boyfriend, Jeff, I think she provided info to the other conspirators to try and set Jeff up to keep her family out of the light. Ooh, shit. I think the state is going to do everything they can to charge her with something. I just wish we knew when. Wow. I know she's panicking after the verdict was delivered last night. I think they have enough evidence to convict Wendy for accessory, possibly even conspiracy, but they haven't done it yet because they needed her to testify in Donna's trial first. It's a domino effect. Well, she's pretty clever. She's pretty clever with that. Even believe they should be able to convict Harvey for accessory. I don't know if they can get there. Not based on the evidence of what we know. He knew. I don't know if they can prove that. He knew and he didn't do anything about it. Just went along with Donna and kept quiet. That's interesting. See, that would require some additional instruction in the law. It's not enough for you just to know and not report. Passing out a piece of paper, we saw that. So that is the feedback from the jury foreperson. Very fascinating. So Linda Bailey, everyone talks about Linda Bailey. So I guess that's where we have to go next. Linda Bailey. Pretty clever. That was pretty interesting. I will say TikTok is an interesting forum for a juror to go out there talking, but I don't hate it. I mean, it is what it is. So I think, all right. Okay. So there we have it. Jury foreperson speaks. Very fascinating. Let's catch up on this and then let's actually go and talk about Linda Bailey, shall we? Let's talk about this. Because I think this is a failure on the part of the defense. I really do. Because there were points to be made. They just really failed in doing it. And their witness did not give on very much. All right. Playing catch up. Brianna Ruffino. I was so glad I hired counsel for my divorce. I'm living my best life. My first date is Sunday. Have a fun date. Thank you for being a strong voice for family law. Brianna, glad you're through this part of your life and on to the next chapter. Hope you're living the best life, man. Really do. Nancy Druby, Rob, I have to say I thought of you right away when the family law lawyers were called in Adelson. All the second one did was repeat what was said by the first and piss people off. She didn't. The first lawyer I thought was more impactful. The first lawyer was talking about this divorce. The second one was like, hey, I just reviewed it from the outside. I have a problem with that. But we'll go through that. But thank you, Nancy. Catlin.
Guess whose phone died?
Yours. Loving me some F&F, getting everyone ready for a Special Olympic State softball tournament this weekend. I'm one proud coach. We'll send updates. Please do. You've been on a tear with this. Hope the team does great. Story time. What's the legality of vice lawyers remaining anonymous during court proceedings? I don't know. I haven't covered it. And I don't plan on it. So kind of off topic. Chrissy, see, my sister got burnt out divorce practicing family law. She's now back in criminal and does some child advocacy work. It's tough. It's a lot of emotion you have to deal with a lot of time. Julia 543, RA's great emergency babysitter, juror, TikTok 1. Okay. Kimberly Fisher, you notice she was in handcuffs, right? She's acted out many more times before with this judge. She has. She can't keep her composure or just chooses not to. Katie Malum, DA's attorney reminded me of Elaine. Hot mess.
Ooh,
Donna
that's
Adelson
not
started.
good.
That's not a good comparator. Shy Gal 8, Carrie Morrissey vibes. Carrie Moore, I can see that. Like coming in way too hot. Maybe. I can see that a little bit. I thought Carrie Morrissey was more effective.
Yeah, Morrissey got the job done when she didn't have the case blow up on her.
Yeah. Gen V, Rob went to New York for work, stayed to avoid his mom. I think that's Rob Adelson, not Rob me. It's like, I didn't go to New York. Yeah, Rob Adelson. Yeah. I think Rob Adelson was the smart one there. Hokey Leah.
Did you see the comment by the family noting that they're still in touch? Like the Markells stay in touch with
Rob? I did.
With Rob? I was like,
I did.
Ooh.
I did. Hokey Leah, do you think charges against Wendy are imminent now? Lots of evidence on her, Donna's trial. I thought I'm of the mind that you let, if you are going to charge her, I don't see any harm in letting her panic a bit. You've got eyes on her. See if she does anything. Lock up the evidence even more. You've done this trial 4 times before, 5 times now. So maybe
send an undercover just to say like, hey, I can get you out of the country.
God.
For $50,000, I can get you out of the country. I can.
Lynn Tolleson, Jackie called Professor Markel Danny. Isn't that unprofessional not to call him Professor Markel as the state did? Was it tactical? What's your view?
It was
They
tactical.
tried to. It was tactical. It was very much tactical. Here's the problem. You can't call the victim by the first name and personify them and keep referring to the defendant as your client.
Yeah, I mean, they wanted to be like, we're all on the same, like, we're on, Danny's side, right? That's what they're trying to do. And, I mean, it's, how do I put this? It's tactical, but the tactic wasn't good.
Yeah. Swing and a miss. It was, if you do it, you have to do it consistently and you have to do it in the right way. Minnesota knows.
And you got to have a client where it's going to actually. I mean, I think that they needed to call her.
Oh, Donna?
Yeah.
They did. But
she needed to get up on the stand and cry about, about how sad it is that Danny's gone. Like we fought, but it's really, this. That's what they needed. So
man, that would have taken the 3-hour verdict and put it to a 1-hour verdict. You know as well as I do.
Well, the problem is I don't think she could have shed a single tear for him. But
they needed her to.
They needed her to get up on the stand. They needed her to have, a successful defense required her to get up on the stand, explain away this stuff, and to and to actually be believed and sympathetic. And the problem is, I don't think she could do that.
This is also where I might be reading a little bit much into it, but when the juror says we saw her outburst, there's a part of when she says it and how she says it that makes me feel like it wasn't the first time the jury picked up on her emotional reactions to certain things. And it's also one of those things, which is why you tell your client you are to show no expression whatsoever.
Yeah.
If you feel like look at like an expression, here's a notepad, stare at it. I don't give a shit what you write in it. You look down. Like if you can't manage your expressions, look down. Because the jury picks up on everything. Do your best impression
of a dead person.
Minnesota knows I was booted off a jury because I told the DA I didn't trust him or his office, which is unfortunate because I think I was the only one that wanted to be there. Morgan, Rob emailed you the Sarah Boondocks and links. Thank you very much. I will take a look at that and perhaps cover it next week. Alicia Vasquez, I've never been on a jury. Is it normal for the jury to vote so many times if they all knew their vote in the first hour? Sometimes yes, sometimes no. Does it depend on the floor? It's not the floor person, it's the foreperson. F-O-R-E.
I'm guessing that
foreperson.
was just cell phone auto.
It might be. Foreperson understanding their role. There's no real rules. Some judges will give guidance on what the jury should do. You should go back, you should elect a foreperson. But there's no real rules. They go back and they can talk about, I don't know, their kid's softball game. There's nothing that requires them to be immediately on topic. But at that point in time, when they go back and deliberate, the severity and the significance of what they've just been through for the last several days, weeks at times, usually has an impact, and they take it pretty seriously.
And often the first hour of deliberation is just like, hey, isn't this some crazy shit?
Yeah. What the fuck? It's pretty much like the what the fuck moment. Like, did you guys remember that time? Remember that time?
And oh my God, we can finally talk about this.
Yeah. Kimchi, I think she did an outstanding job. This is how seriously I want jurors to take it. Shaking my head at people hating on her for being young and taking it seriously. I think people are just going to have perceptions one way or the other. Kelly Kell, I'm a 3L and started evidence. Tanner versus US with the drunk and high jury is a wild example of what can happen when peers come together.
Wait, what?
Oh, yeah. Jurors can do any number of things.
Wait, what?
I don't remember the specifics of that case. I'm going to look it up, but I do remember. I think it was conspiracy to fraud the United States mail fraud case. Okay, it's a mail fraud.
But like, what was
the?
Oh
yeah,
this thing about drunk and high. I mean, the mail fraud I don't really care about. It's the drunk and high part that
the attorneys discovered that 7 of the jurors were drinking during the noon recess. 4 of them consumed between them 1 pitcher to 3 pitchers of beer during various recesses. Of the other 3, one said that on several occasions he observed 2 jurors having 1 or 2 mixed drinks during the lunch recess, and 1 other juror who was also the foreperson having a liter of wine on each of the 3 occasions.
Wow, good for them. I am, of course, kidding. That is not good for them. That is like horrific. But
it's the Rule 606. You can't impeach the jury verdict based on juror statements. So
yeah, I feel like that rule is not super great in this particular context.
Well, you know, Supreme Court cases get made based on the worst facts. Like that's it's not pretty. Which is why bailiffs usually keep an eye on juries now. Just saying. Because that if someone, let's put it this way, if someone had observed those jurors doing that during the course of the trial, different outcome. Juror gone. Bye-bye. Different outcome. But not that, Janet. Is it true that is it a true jury of our peers if it's only those who can afford it? Nothing against her, just seems not quite right in general. That's just a little flaw in the system. It's companies have started offering compensation packages that include a benefit like this. Short-term disability will sometimes pay for it, so it varies. Gen B, my employer offers up to 4 weeks. Yep, there you go. My employer offers up to 4 weeks full pay for jury duty. Got a jury questionnaire last week, and I'm a law nerding out. Yeah, some employers offer it, and then also some short-term disability policies for employment will also offer coverage. The girl Bonnie, love how thorough she was. I would have had the first vote be on a paper and anonymous though, to avoid poisoning the well or the power of the suggestion. It's not a bad idea. Katrina Turner, Ian, one of my dogs is also a scared furball, but their Wolf Malamute mix rescues. That's not a breed you fuck around with. So size alone would stop most folks from with some self-preservation. Yeah, not to fuck with. Luna Dewdrops, question for both of you. If Wendy is indicted, do you think she can use "I was a victim of my controlling abusive mother and family" as a viable defense and have a strong case? No.
No, she's still going to be like, if somebody really abusive and manipulative says, go murder a dude, the law
Yeah.
expects you to be like, nah, I'm not going to do that.
Yeah. We place agency on the individual making the decision. Now, let's change the facts a little bit. Don't you dare tell on your brother. And if then you've got the don't tell your brother, and that's a manipulation, but she doesn't actively engage in any of the steps that actually do the murder, maybe a different story. I don't know that she actually gets charged there. But under this set of facts, if Wendy gets indicted, you ain't gonna be able to rely on the whole my mom was controlling. She's gonna try, especially if it goes to a jury. AT1 CVB 41, 2 years, 1 month. Hope all are well. We are. Hope you are well as well, friend. Michelle Maynard, in my opinion, Wendy is the mastermind, the puppeteer of all. I don't know if you saw her testify. I don't know if I buy that.
I don't think
Nancy
she's a
knew-
mastermind.
I really don't. Nancy knew too. They would have had to have been super careful to go through all the testimony by Wendy before charging her due to her immunity and make sure what they could use. I imagine they
they
could
have
take a look
a.
at her.
They almost
Sorry.
certainly have like a box of like, here's the stuff we can use.
The limited use immunity was probably the easiest damn decision the prosecutors had to make. They've run this trial 4 times prior. They know exactly what they would use against Wendy if they prosecuted her. They don't need a single word that she says on the stand because they have prior statements that they have recorded of her talking to officers. They don't need shit. So the use immunity was a no-brainer. Torin 3, wish me luck. I finally get to see the neuromuscular specialist this week. Good luck, Torin. Good luck. Also spending productive time in the shop making things. Hope all goes
That's
well.
even better.
Hope the shop is in good condition. I know you were working on it a little while ago. Southern Mom, happy Fry. Yay. Do you think that the short deliberations, 3-ish hours for Charlie and Donna both would factor in the likelihood of charging Wendy? Yeah, a little bit.
I mean, I think it's probably a consideration. And I'm sure that they're looking at like the juror interview or the juror TikTok, thing and going,
We can do this.
How does that work for, because if the juror was like, we really weren't sure. And also if the juror was like, yeah, they said Wendy was involved, or, they said Wendy was involved and we don't believe that for a second.
The jury apparently was on board with the Wendy did some shady shit. Now the question becomes for the prosecutor, let's say all the cards fall on the wrong side of the deck that day, or let's say the cards all fall wrong in the evidence being borne out. Does that gut feeling the jury has of we think they did something wrong, but did they prove it? Can you actually overcome that? Like, can you prove it with the facts? I don't know. That part's harder. Prosecutors booze cruiser tours. In Ireland, employer legally has to pay any employee that's called for jury duty.
I think that's a good system.
It's not a bad system. Big Apple Hoosier. DNC made Donna and Charlie made several comments Wendy didn't know. That's true. I think there was different aspects to this. WW attorney Fulford said started as a prosecutor, then became a judge. She was forced off the bench and now runs her defense practice out of a funeral home she owns. I didn't know the funeral home part. Knew the other part.
The funeral home part is kind of legitimately hilarious. Because it's like, oh, right. Yeah.
It's kind of weird. Yeah. Big Apple Hoosier, my friend knows Wendy. She's conniving, evil damsel. These people they ran in certain circles. I imagine there's a lot of opinions around there for a lot of people. Nick Starrow. Nick. We talked about the judge who refused to lower bail so the defendant couldn't afford Alan Jackson. I did not. I didn't see that article or that news report. Please feel free to forward it to me. That's pretty wild. I think there were statements on the record. That would be quite the appeal issue if that was the case. Right to counsel,
specifically trying to interfere with choice of counsel. It's
Pretty significant. Feral Dragon, in the name of LawTube, in order to create a less dumb union, I'm teaching 5th grade logical fallacies. Hopefully they'll apply logic and not fall for BS. Well, one can hope. One can absolutely hope.
Hope springs
Okay.
eternal.
Without further ado, let's get to the people that people wanted me to critique. We're back in court and we're actually hitting the rewind button a little bit because now we got to do the family lawyer critiques the family lawyer and whether this is bullshit or whether this is real. Did double swoop just to do the double swoop. Oh, saw this come in. Ada Shaw, thank you very much. Very generous of you. This juror did an excellent job and they got the right verdict. In my honest opinion, what is there to complain about? Thank you from a first timer. I'm not complaining.
Welcome, first timer, and
Welcome.
yeah.
Very glad that you're here. I'm not complaining. I think it was great. I like learning from these experiences because here's the other thing. Everyone always thinks that the system is supposed to work a certain way or that it works a certain way. It doesn't. I try to personalize it to make you guys understand that courts should not be scary. Yes, there's serious consequences, but you have to be comfortable with that setting. I think the jury did a good job. I think I have no judgment on what that juror did. Now, the juror in the Johnny Depp case who might have wanted to fall asleep a couple times. You remember him?
Uh-huh.
Uh-huh.
I didn't actually see him nap.
No.
I just saw him look like he was really struggling at times.
There were a few times when you're looking at Judge Ascarati and Ascarati's calling a break, and you know damn well why she's calling that break.
Yeah. It's like, all right, this guy's going to fall off his chair.
He's going to fall asleep. Yeah. So that, look, this is what voir dire is for. You're supposed to really filter through who's going to actually do the job, who's going to do it well. And by and large, the process works. So, yeah. But, thank you for stepping in, hanging out with us, Ada Shaw. Very much appreciate having you on board. I hope to see you again in the future. All right. Oh no, Lobby, our boredom canary. He was
great for that.
Was so funny. Oh God, I forgot about him until like this thought process. Oh, he was my favorite. Nope. The lady who was like, "You fucking kidding me?" That lady, she didn't say it, but you know what I'm talking about, the skeptical one.
Yeah.
Yeah.
He's got the expression of like, really?
Like, are you fucking kidding me? Yeah. It's let's say it's pretty pretty funny.
I see somebody saying the funeral home probably explains her wardrobe. Are you suggesting that was a used suit?
Usually not one to make comments or critiques on the wardrobe, but as I have said in the past, as a lawyer, your job is to speak and your job is to be the mouthpiece. And if people can't focus on what you're fucking saying because of what you're wearing, you're not doing your job. Just
your
saying.
Suit should be at least within like 3 sizes of the correct size.
Which is also, it also goes to I'll speak on this one, to Georgia Kaplan. Her red suit is a bold choice for a prosecutor.
Yeah.
That one was a bold choice. I don't think I have ever seen a prosecutor wear a red suit ever. I don't think I've seen counsel wear a red suit in court. That choice screams confidence. Now, if you botch the clothes, it also screams idiot. But in this case, it was confidence. So, okay.
affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor.
What do you think? 1.25?
Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 19.
All right. So how do you know out of the gate this is a litigator? Second fucking question. Did you catch this, by the way?
No, go back.
Ready?
Tell us briefly about your educational background.
My post-high school educational background.
Did you catch it that time?
Yeah, my post high school. She's being very particular.
She reframed the question
Yeah.
immediately reframes the question. And it's almost like a judgment that kind of is like, you didn't ask the right question, so I'm going to go ahead and clarify for you. Just right off the bat, you're going, oh shit, this is going to be funny.
I mean, the other thing she could have done to be a dick is like, well, I went to elementary school at. Yeah.
It was funny.
Background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adelson, so we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school, and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law. And what that requires is an application that's about 3/4 of an inch thick that details all of your trial practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross exam with, et cetera. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
And before we continue,
What's this to become?
This is the board certification. So it's Florida is one of the states that has a certification process for different specialty fields.
Okay.
Now, here's the thing. I think this was a tactical error on the part of the defense. And I'll explain this one, and I'll pull her down to explain it. Ian, if you were looking for, let me put it this way. If you've handled 2,000 criminal cases ranging from petty larceny to statutory R to battery to murder to capital murder, and you've done that for 2,000 cases, if I were to ask you with that body of experience whether a case is largely complicated, do you think you might have a perspective that might differ from the average person?
Yes.
This woman has probably litigated more divorce cases, complex custody cases, and family law cases than, I don't know, 90% of the bar in Florida. I wouldn't be surprised. So asking her whether something is a complex case or highly contentious, she has a perspective on it, a perspective that perhaps is informed by years and years and years and years and years of seeing the craziest shit in the world. So right off the bat, the second that she starts going into her background, I'm like, oh, she's seen some shit. Which immediately makes you wonder, is she the right person for the job? This job, trying to explain this down to the jury.
Continue. The clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, B-A-I-L-E-Y.
Thank you. How many board certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
And do you know what percentage of lawyers in Florida are board certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily.
All right, this is going to be a clarification. So there's only 270 members of the family law bar in Florida. No, that's actually not the case. So there's the board certification, but you don't have to be board certified to practice in the field of family law. So as a licensed lawyer in Florida, you can practice in family. You can practice any type of law. You can practice criminal law. You can practice civil law. You can practice any type of law. You don't have to be board certified. Some people will take the advanced route of seeking board certification because it's a credential that sets you apart from your peers. So, for example, if I'm looking for a divorce lawyer in Florida, and I really want to know whether someone has a certain level of experience and can handle a complex case, I might look for those individuals who are board certified, people who have gone the extra mile, not just your standard lawyer who's done a bunch of divorce cases, but someone who's has this body of work and has this level of experience where their peers, the judges, and the tests that they've taken have said they know what they're doing. Not a little bit. They know it to the point where they are board certified to practice in this field of law. So no, it's not that there's only 278 family lawyers in Florida. That would be impossible. It's that there's 278 of them that have this level of certification. That
You know
are
what this also
experienced.
tells the jury?
What?
Donna's big money was paying for some big power, heavy hitters.
Yeah. Yeah. This lawyer is not cheap.
I think this is partially a mistake, emphasizing that because that they're all you don't want to emphasize the money.
They should have left her lawyer on the stand longer and cut Bailey out. It would have been more impactful. Have her lawyer explain the ins and outs more, cut Bailey out of it. But that's just.
Lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to
and they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday. And then after the course, you do co-mediations with other mediators. And then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education. It might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for.
It's a little political, but that one is not one that gets paid for. So the U.S. News one and the other ones. So
yeah, that's the thing I wonder is because like anytime
somebody's
got an award. Okay,
this is not a paid for one. Who's Super Lawyers too, but Super Lawyers doesn't say a lot. I'm a super lawyer. Like, it's someone votes for me. I don't know what it is, but it is what it is. I don't pay shit for it. No. So let me clarify. A lot of people are saying she's full of herself. She doesn't understand the sequestration rule. Let me make one point very, very clear. You would not want to see this woman in court. In no shape or form. No fucking way. She is a tried and true litigator, and she would probably eat whatever attorney you would put up against her for lunch. I'm not kidding. I know a couple of lawyers in the Virginia area that are kind of like her, and I would not be intimidated by any of them, but they are damn good. She might drive people nuts, but in a courtroom, in a divorce case, in a family law case, I imagine she is on the realm of do not fuck with this person. Just saying. To have the level of experience that she has, the accolades and the accreditation, that's not like just going to school and just learning like book smart. That is shit that happens in trials. Like she has legit courtroom experience, not just legitimate court, 37 years of it. And that's, again, goes back to what I think the problem is. You picked someone that was too experienced, someone that had way too much experience doing this stuff. You needed someone that could explain it at a level that the jury could very easily connect with. This ain't that person. That's the problem. The difference between her understanding of family law in court and the juror understanding of family law in court is just you're on different worlds. You're on different planets. She's never going to be able to connect with the jury. I could have told you that if you had given me her resume, given me her experience, and just told me I am talking about having this person testify in front of a jury, I would say you're out of your fucking mind. No way. That jury she is going to speak at a level that jury will not understand. She is going to have no ability to connect with them because she has not seen an average divorce in maybe 20 years. So yeah, that's the difference. Oh, y'all think Georgia scored points in cross-examination because Georgia highlighted what I just said. That is it. It wasn't that she was right on any of the legal points. It wasn't, and Georgia's wrong on some of them, like dead wrong. But she highlighted what I just said, the difference between this person's lived experience and this person's lived experience.
Many years, I'm not sure how many. They've also recognized my law firm as best law firm in America and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review. And the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests. Like, have you provided presentations? Have you taught? Have you done certain community service or pro bono work, that sort of thing?
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where
I was like, there's a Legal Aid Thunderdome. I need to hear about this.
Family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers.
That's fucking awesome. That is so cool. Yes. Please, can you teach judges too? So there was a question. I'll highlight this question so I can clarify for the chat. Chat, why is Rob talking about this case? Or why is Rob talking about this? DNB. Rob, can you explain to the chat what kind of law you practice? Lots of new subs might not know. I am a divorce lawyer. I'm a family lawyer. I'm a family law litigator, trial lawyer, just like this person. I've been doing it for 15 years. She's been doing it for 37. Doing it for 15 years, pretty good at it, I would like to say. I have enough experience where I'm not really intimidated by anybody, whether it be her or anybody else. But there was a whole lot that was brought to bear here. Let me put it this way. It would be better to put me on the stand with 15 years experience than to put her on the stand with 37. I am still close enough at the beginning of my practice and the regular people that I see on a daily basis to recognize that, holy shit, $80,000 might be a lot to some people. Just, or at the very least, to make the testimony not feel as abrasive. But yeah, so I'm a family law litigator. Been doing it for my entire legal career.
And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
Yeah.
State wished to without the witness as to their training or experience. In objection to her ability to provide an opinion in the fields of marital or family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendy Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendy Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendy Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendy Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother, but most of their communication, I think, was by email. And I reviewed the emails that I was provided between Wendy Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendy Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage act?
Okay. So this is also something I'm going to bring up at this point. Lee, the defense didn't give her all the emails. She reviewed the court file. Let me tell you what all of the emails would have looked like. In a divorce case, our discovery packages often include email communications, text messages, and phone calls between the parties. Thousands and thousands and thousands of pages. People going through a divorce send a whole lot of communications back and forth. When I walk into trial, I like to think that I have read every communication between the parties, but I would never stand up and swear under oath that I've read every communication between the parties.
Unless there was only
possible.
like 3.
Yeah. So this is the other thing. If I intended to call this person as a witness to testify as to the complexity of a divorce case, you better fucking believe I would have gone through and found the most egregious emails that were probably going to be shown to this person. It was a really dangerous move because all you got to do is take out 1 or 2 emails or text messages, and all of a sudden this person looks like an idiot. Like, oh, you didn't see this massive communication? And that also goes to the whole experience thing. We'll get to it during the cross. So we'll fast forward the direct a little bit. I was also glad Zellman did this direct examination and not. Could you imagine if Fulford did the direct on this witness? Oh, torture. But we'll fast forward a little bit into the direct.
Position, and maybe theirs will change.
Yeah.
It should get a second opinion, and generally they don't. And I say, this is why I don't think that advice is valid or is
there's a relocation.
And they or whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients family members or friends are offering advice and it's passed on to you.
Sure.
How do you address that?
I ask them to call me. You know, sometimes I say, you know, if you don't trust my advice, maybe you should get a second opinion. And generally they don't. And I say, this is why I don't think that advice is valid or is going to help you. And we can have that dialogue. And if they're
Okay, so that's bullshit. Let me give you the real answer that she actually should have said. Do you have family that calls you in the middle of a divorce case or that likes to voice their opinion in a divorce case? Yes. Yeah, all the damn time. Every time, especially with younger parents. Like if I have a 30-year-old client or a client in their 20s with 2 small kids, you better believe that mom and dad are, if not direct CC'd on the emails the damn client sends me, then they're blind copied on them. Or it's, can we have a conference call with my dad on the phone or my mom on the phone? All the damn time, every time. She downplays this. Really dumb. It's really dumb. Like, what do you do when the parent wants to be involved? Well, maybe I tell them to go get a second opinion. No, you don't. You know damn well what you do. You know damn well what you do. You either A, get the parent on your side of the equation and make the parent understand they can't be involved in every fucking discussion, or B, you have the come to Jesus talk with the client and you're like, your parent can't be involved in the conversation. It's a waiver of privilege. Or C, you boot the client. You say, bye-bye. I'm not dealing. And usually the boot the client thing, and it's, here's the thing. This is why it was frustrating. She's not clueless. She's not. She knows this. She absolutely knows this. She knows this. She's just giving a bullshit answer. She's giving the bullshit answer. She's giving the very PC, gentle like answer, and everyone knows it. We all know it. It's the bullshit answer. No, you know damn well. And then mediation, bringing third parties into mediation, you actually can do this and still maintain confidentiality. It's still possible. And I don't hate that idea, to be honest, because I will have clients that will walk into mediation and they will say, but I'm not going to reach it. I'm not going to make an agreement until I can talk to my brother or my family or my cousin. And it can completely destroy mediation. And no matter what you say, that client doesn't trust you enough because they still need to talk to their confidant.
really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position and maybe theirs will change.
Now, you were provided with a number of emails that Wendy was sent by her mother. Did you see evidence that Wendy shared those with Kristen Adamson?
I saw no evidence that Wendy shared them.
And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
It's bullshit too. That's bullshit.
But that the grandparents are commonly there at hearings?
That the attorney didn't know that the grandparents were involved. That the attorney didn't know that a lot of this, because let me tell you how you can figure out that a third party's involved. You talk to your client, you're on the same page. 45 minutes later, you get an email from your client that's a ranting email to you, yelling at you about why you would possibly suggest something that you just suggested.
And that they were on board with 10 minutes ago.
Exactly. That's how you know that the family's involved. You're not that dumb. Like you know damn well that Donna was involved.
Did Wendy Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days with 5 days and then 1 day in the off week. So he split up a little bit. which was a typical parenting plan for that time period. So she got more parenting than she had really asked for. And that was to last 3 years. And then it went into 50-50. I think that got the youngest child to school maybe. So they did, until the youngest child went to school, she had about 55% parenting time, child support, you know, the division of childcare, that sort of thing.
And without going into too much detail, child support is a mathematical.
It sounds like that she had a good lawyer that knew that this was going to be the outcome at trial, and therefore that was what they proposed. And that was why it became an agreement, even though it was a begrudging agreement. This to say that this is like peaceful is true. Now, did mountains get made out of molehills? Probably. Let's see what happens.
Calculation.
It's a formula.
And it's based on a number of factors: income, childcare, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions.
Wrong. 100% wrong. Wrong. In all facets. So let me clarify something. This is why reading the pleadings and starting with the pleadings can be stupid. Because the pleadings, in a pleading, the rule is if I don't ask for it, I can never get it no matter what. Why, like, people freak out when they get served with a complaint for divorce. They're like, they're asking for attorney's fees. Are they really thinking I'm going to pay their attorney's fees? No, they don't. They have to ask for it, because if it's not in the initial pleading, they can never ask for it again. They can't raise it later, like, or try to cure it. So they're going to put the most extreme thing in the pleading for their request, their prayer for relief. My prayers for relief in custody cases where this thing's being litigated, sole custody, sole legal custody, sole physical custody, or in the alternative, a parenting time agreement that is in the best interest of the child. Pretty straightforward. So, no. Now, sole custody, sole legal custody, sole decision-making. She doesn't clarify. Was this in the pleading itself? Was this what he actually expected? And then there's other caveats here. Let's say, for example, one parent, the child is going through and has ADHD. Great example. Child has ADHD. And one parent is like, I think the ADHD is manageable with note cards. And the other parent is like, there's been 5 outbursts at school this past month. Why don't we try a medication? And the parent's like, I don't believe in medication. I want to try the note cards. And the other parent's like, well, I really think there should be medication involved. And the doctors are like, 2 doctors are like, I think medication should be there. And then one doctor is going and saying, well, we should just do hypnosis. And that's where the parties are, right? They can't decide on whether to medicate the child for ADHD diagnosis. Pretty limited issue, right? You're not actually taking away everyone's power. You have a very discrete issue that has to be resolved. Who's going to make the decision? Whose decision should be given priority? Because this kid's having outbursts in school. We got to do something. Either we're going to hypnotize the kid or we're going to medicate the kid. We're going to do something. So
We could do both.
setting, we could do both. We could hypnotize him and medicate him and then hypnotize him again. So in that setting, a parent petitions to have exclusive decision-making authority, with the limited scope being on the issue of ADHD treatment or medical decisions or mental health decisions. Wow. Now, if the 2 parties disagree every day, all the time, and they're never going to reach an agreement because, divorce and they hate each other, then the judge has to decide a tiebreaker, which is usually someone having sole decision-making authority. We ask for this routinely, all the time. We ask the judge to give tie-breaking authority when the parties have a full discussion. In the event of a disagreement, judge, make a decision. Who should break the tie? All the time. So this is where you don't really clarify. Wait, where is it? Oh, yeah. This is why. Okay, Ryden, why do you think I came up with the example? Why do you think I came up with the example? How many times do you think I've litigated that exact issue from both sides of the aisle? That's what I mean. So you can't generalize it like that and say, oh, he would never get sole decision-making authority. Well, really? Really? Because if she converts to Catholicism and he's Jewish and the kids, one is Orthodox and the other one is devout Catholic, those two religions, you can't practice them equally. You can't. There's certain things that just don't line up.
Like the whole, like, don't be the other religion thing.
Don't be the other religion thing.
Most religions have as their first precept that you can't be another religion at the same time.
If two parents, both of which have equal authority and equal power and equal right to make the decision, if two people in equal position cannot decide whether the child is going to be raised Jewish or Catholic, holy shit, you got to have experts. You have to have a judge decide.
Now, what about if one parent wants to have them dress up in SS uniforms?
Well, that might weigh in the judge's consideration of which parent ability to make the decision. Maybe the parent that's not like, I want to dress the child up as little mini Hitlers, should make the decision on which religion the kid should be. This stuff gets litigated all the time.
It's like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Great example, Emily. Great example. Love this. What if, and hear me out, we don't do any religion and they pick which one, if any, religion they believe in. That's all well and good. And this is why general statements that this lawyer is making are not helpful. Because you know what's funny about family law? It is very family specific. Oh yeah, it's very family specific. Different people value different things on different levels. Okay. So for one family, maybe religion isn't the be all end all. And maybe that it doesn't matter. We can wait till the child becomes of age where they can make their own decision. But for other faiths, for example, in Catholicism, baptism occurs at birth, because between the age when that child is born and when they can make the decision to confess their sins and receive absolution, that time period is a time period when that child in the faith is not protected. So, which is why we have baptism. So it's very important to families and people and individuals and families to make that decision. And there has to be someone standing in the breach. So for every family, it's a little bit different. Every family is a bit different.
Did Mr. Markell get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that by agreement.
And you mentioned keeping the boys kosher. Was Wendy Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markell to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendy Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markell granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendy Adelson required to continue counseling with Mr. Markell and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court.
All right. So again, stop the generalities, the generalities. when faced with two parents that cannot decide for themselves, the court cannot say, I'm going to pass the power off to somebody else. I'm going to let this person decide future conflict between the two of you. Right? The judge can't look at two parents and say, y'all ain't coming back to me for this decision. I'm going to make you go to a therapist, and the therapist can be one to decide. You can't do that because the judge is the one who has to be the ultimate arbiter of disputes. They can't delegate their authority. However, it is routine in our settlement agreements that we don't really want the parties to go back to court every fucking year. So
Or 10 minutes.
Yeah. So we put in our settlement agreements, hey, the parties will consult with the parental coordinator. And until such time as a judge can intervene, or until such time as one of the parties objects, they want to file a motion, that we will go with the parental coordinator's decision. So the judge has not delegated that power. The parties have. It's a nuance, but it's one of those things where this is why it becomes problematic to speak in generalities. Let's say hypothetically that a person on this jury had a settlement agreement with the spouse that had just that provision in there. This person lost all credibility with that one statement.
Can't say you need to go to your therapist and follow their advice.
Was Wendy Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markell?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements because kids don't want to see the parents fight every birthday.
Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement?
No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markell ordered to pay both Wendy a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendy Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markell's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
Also be punitive.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendy Adelson?
Yeah. Yes.
But how would you know that? Like, did you know what facts she had going into the trial? Did you know the on the ground, like what would have presented had trial gone forward? Like maybe Wendy Adelson would have walked in and I don't know, just completely proven that Dan Markell, I'm not saying he was, that Dan Markell was, I have no clue, an abusive alcoholic or something like that. You have to know the family. You have to know the family. You can't just make a general statement like, yeah, it was favorable to her. Cool. You read the pleadings. How do you know that? Did you go through the discovery? Did you review all of the things that were there? Did you know what they were going to prove at trial? It was favorable. Cool. You know who's in a better position to say whether it was favorable or not? Wendy's actual damn lawyer who just testified. Why is she not being, why are we not relying on her? Because she's the one who knew what they were going to do in court. Or ask Wendy. What the fuck? How is she going to make an opinion on whether this is what she thought she was going to get at trial? She doesn't know.
Now, later,
It was very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those and they got a very typical marital settlement agreement.
So from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markell were due within 60 days. So that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, well, what's left of the 120, 70-ish, plus the 10 for fees.
Okay. So Mr. Markell had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
That's pretty quick. Just saying, like, call it quick. Like, don't.
They're trying to say, oh, she gave so much grace.
So much grace. So much grace. Let me tell you what happens in 30 days. Not a lot. It's stuff like this. Like you downplay the things that you really, you don't have to. Just say, like, it was kind of aggressive. I will believe you more.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't.
Not a question pending. There's not a question pending, counsel. There's not a question pending. You know this rule. Don't fill empty space with words. You know better. But lawyers like to talk. Hi, I'm an example of that. I like to talk. Ian, raise your hand too. You like to talk as well. Yes.
He's lying.
Ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Yeah. This is wild to me in Florida. You can't jail someone for not satisfying a court order. In Virginia, you can. Don't, if you're in Virginia, don't play this game. Don't play this game of not paying things on time. A judge will absolutely lock your ass up. Don't do that.
Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendy to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendy was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendy waived her right to appeal that by agreeing that the relocation will be dismissed. So
now, prior to final judgment being
okay.
So
She's
she wasn't on the file at all. I missed this the first time because I listened to this in my car. She wasn't on the file. She's just reviewing the pleadings.
This is like me coming in after the fact and trying to give an opinion on what a judge would have done in a case like this.
I have some opinions on this.
She doesn't know the other perspective. She doesn't know the other side. She just read the pleadings. Here's the thing. We put a lot of shit in pleadings. A lot of stuff in pleadings. With no intention of making that argument in court. All the time. Especially in family law cases. You know the amount of shit that gets thrown in pleadings in family law cases? Let me give you a hint. A lot of it has to do with husband putting his penis where it shouldn't be. Or wife putting her hoo-ha where it shouldn't be. All that's all in pleadings. It's in pleadings. So we say a lot of shit in pleadings. Oh, this is great. I do love this tactic of giving the experts sanitized material so they can testify something doesn't exist. Yeah, this was not contentious. This was not. Here's the other thing about this. She knew the motion was lost. Ma'am, I know you are too damn good at your job. Not. I have entered into settlement agreements. This is gonna be relevant. So I'm gonna pull this out for a second. I had a case, very contentious case, where a mom never held a job, 2 very young children, under the age of 3, 2 kids under the age of 3. Mom never held a job, and the dad worked full time. And I represented the dad. And the mom had no family in the area. None. No support system. No, nothing. So the mom took the kids, moved to where her parents lived, about an hour and 40 minutes away. Well, that sucked a lot because my client was a good dad. And we end up in a mediation. And we're talking settlement. Family lawyers, the other benefit about family law is a case is never necessarily final. It is final until there has been a material change in circumstances.
And material changes in circumstance happen all the time.
All the time.
Because it's like, what's the material change in circumstance? I have a tummy ache. And I didn't have a tummy ache when we did this last time.
So a good lawyer will win their trial. A good lawyer will win their trial. They'll make their arguments. A great lawyer will not just win the trial and the arguments they have in front of them. They will anticipate the next material change in circumstance, and they will have positioned their client appropriately so that when that transpires, as they predict, their client has an advantage or the other party's boxed in. In the hypothetical I'm thinking of, we went into negotiations and we were not negotiating for the outcome tomorrow. I wasn't. We knew what the outcome tomorrow was going to be. What we were negotiating was the eventual outcome in 2 years. So there were various provisions put into the agreement that set conditions to the extent that dad moved within a certain mile radius, to the extent that the children attained school age and how they were to weigh where the children would go to school and who would be the primary parent for school choice based on what factors we would grade or elevate the schools. I got my client through that settlement. We signed off on it. I got a call about 2 years later from the client telling me that they had just gone to mediation in this other jurisdiction and that the judge looked back at the language and in the judge's opinion cited the exact paragraph that I put in. As a family lawyer, oh, it does. It does. As a family lawyer, you know better. You are not just trying to win the trial. You are trying to affect change in a family. So it is ongoing. So this part was very disingenuous. Not necessarily disingenuous. It was dumbing it down to the point where it just didn't make sense.
Dumbing it down to the point where it's dumb.
Would Wendy have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
She could have.
Would there be anything improper with Wendy or her family through Wendy offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who did to get her to not relocate.
And that's why you shouldn't be talking to this jury. That is exactly why you should not be talking to this jury. The fact that you just said out loud that you had a client pay $150,000 to someone to not relocate means that you are used to dealing with numbers that the average person is just not going to comprehend the same way. Oh, this baby steps. Rob, that's what I meant earlier. You have a warmth and approachability that she does not. You were much more relatable. You would connect with the jury. For example, I wouldn't give the jury the $850,000 bribe. Like as an example, like it's a story you like tell friends. You don't like tell it to the jury to try and say, oh no, this was normal compared to the case where I had an $850,000 bribe.
I would like an $850,000 bribe.
Not to relocate?
Just in general.
God, what a wild thing. Oh, puppy. Got my first dog last November. He's 1 year old today. Happy birthday, puppy. He's a Doberdane. Giant, a handful, happy pup birthday. Scrappy. Oh, his name's Scrappy. Thanks for letting me share. Not that. Lindsay. Happy birthday, Scrappy.
I've seen $35,000 to get a, whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation. So that's routine.
Nothing unusual.
Yeah, it's also very weird. It's very weird. This is probably very off-putting to the jury too, talking about the pain points. Pain points is very real. You find out what's uncomfortable to the other person and you push.
It doesn't make people happy though to hear it.
No,
Juries do not like this.
Nope, not when it comes to family. Like when you talk about civil litigation and contracts, you're like, this part of the contract is really painful on them because it costs them money. The jury doesn't give a shit. Both people have money. But when you talk about like custody cases and you're like, you find the pain point and you push. Like, for example, an exchange time that is like 5 o'clock on the dot. Most people don't get out of work at 5 o'clock. 5 o'clock becomes very hard. So you find that pain point and you push. This is why you might say this to a colleague.
This is why I like criminal law. Because the pain point is my client doesn't want to go to jail versus, yeah. Somebody said I would bribe Runkle with $850,000 to move to Florida. If that's a serious offer, I could probably get Mrs. Runkle on board.
She might be on with that. Yeah. The pain points in custody cases, we don't talk about them. Like, this is why I said people would have a very different perspective if they saw behind the curtain of family law cases. Oh, thank you. Thank you, Ivy. Thank you. We are notorious bottom. Thank you. That's very kind of you to say. Very kind. Some of us actually give a shit, like actually really care. So.
About that. Now, you testified earlier that you were provided text messages between Wendy Adelson and Dan Markell after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014. So it was a few month period, even after these motions had been filed that kind of upped the temperature a little bit. And they were working well. I saw some communications where Mr. Markell was inviting her to join him in the Boys for Ice Cream. I know that there were many occasions where he was traveling and his travel plans adjusted and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see.
A lot of that amicable can read with context. For example, there were times when he moved his plan. Oh, that sounds very sweet when you say it that way. But when the corresponding email was like, you money grubbing whore, I'm so pissed at you. Fine, I'll move my fucking plan just because you want to be a bitch and do all this other stuff. Would you really say that's amicable? Like, would that be amicable? Like, he moved his plan. Like, this doesn't help. This is just, it's a gloss. I don't have any context. I don't have any understanding. None of this makes sense.
They were very flexible with each other.
Oh. No, Laura M. That's not all the words. All the words in divorce cases are literally all the words. Like I have learned profanities in this.
She's
profession.
like, they were very flexible with each other. And I'm like, not as much as they were with their new partners.
Yeah, sometimes I wish they would decide to be, flexible after they separate. Just saying.
Now, you indicated earlier that October 31st, 2013 Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She
Thank you
was
for
asking
asking
for a
that,
judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it was there. It would be helpful to see the pleading itself.
Sure.
May I approach the witness? Approach with courts 1 states the motion of A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause. And under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendy is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line. But then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same, order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court.
Oh, that's it. Oh, that's it. Stop downplaying it. Stop trying to explain pleadings that way. Oh, it would be more normal if you just said, yeah, every pleading is going to ask for the kitchen sink. Every pleading is going to ask for the kitchen sink. Just tell the jury that. It's easier for them to understand.
You ask for everything because if you didn't ask for it, you can't get it. So you ask for the sun and the moon and the stars, and you think maybe you'll get a star.
Yeah, it just explain it to the jury that way. Stop. It is easier to explain it that both people go in yelling and screaming, but at the end of the day, they realize the yelling and screaming ain't going to get them anywhere. And they reach an agreement. That's what it is. It's adult children that are managed by their handlers, which are their lawyers, and the judge marshaling disputes that can't be resolved.
Hold him in contempt here.
Also,
She's
Rob,
just
did you
asking
see
the
the
court to order
Spider-Man?
him to-
Which one? What? Yes, the meme. Oh God, the best meme, best audio visual use in a closing argument I have ever seen in my entire life. It doesn't even come close. It doesn't even come close. She pulled out the Spider-Man pointing fingers at each other meme in a closing argument and put it in the.
I was like, that
slideshow.
is ballsy and amazing.
I loved every ounce of it. And I was like, you better be right when you pull that out. You better be right, and you better have a good read on the jury. But holy shit, did it hit home? Wow.
Yeah,
that
you
was
better
so
hope
good.
the jury's on the same page as you, because otherwise you just fucked up if the jury's not thinking it.
I had to rewind because I was watching it on Recovery Addict stream and I didn't know if he was the one that pulled it up. And I was like, wait, Scott, did you do that? And then I rewinded it. I was like, no, that's
her close.
It was so good.
Pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
No, I don't think it's biased. I think we all the lawyers know each other. We all know each other. We talk about each other in the first name all the time. Just downplaying something that is.
It's a first right of refusal. You need to have a parent.
Oh, here we go. People had questions
as it related to the first right of refusal. Right of refusal, maybe 0.45, and then he kind of.
Hang on.
Did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.45, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendy to have to call him so he could watch the kids, even though mom's there to watch them, which that's not the purpose of a first right of refusal.
False. This part pissed me off.
That is
False.
exactly the purpose of a first right of refusal.
Exactly. So right of first refusal, ROFR, or first right of refusal, whatever you want to call it, is essentially this. Let me explain it to you. So right of first refusal, if I am unable to physically put eyes on these kids for a certain period of time, right? Not an hour, not 2 hours, not 3 hours. Usually it's like a 3-hour period when I can't personally have eyes on these kids. Then I must provide the other parent with the opportunity to care for the kids during that time, because the law recognizes that the kids are probably better suited to having time with their parent than a random babysitter or some third party. Okay. So let's say that I have to go out of town for work and it's just an overnight trip, but it's pretty quick. The right of first refusal requires that I call the other parent and say, hey, I'm going out of town on this particular trip. So, would you like to care for the kids during this time? And the other parent's like, that would be wonderful. Why don't I pick them up on this time and blah, 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 right? That's how it's supposed to work. However, people play games with that, right? So let's say
in family law,
oh yeah, never. It would never be litigated. Never, ever, ever. Let's say I want to go out on a date. I'd like to go out on a date. Actually, I'll use me and Mischief as an example. Mischief and I want to go out on a date. We want to have a lovely date on the town, but it happens to be a week when the kiddos are with us. So, we know that we are going to be back probably 10 o'clock. But we're not getting along with Dad right now, right? So instead of calling Dad and giving him the opportunity to watch over the kids, we're just going to have a babysitter come. We're not going to tell Dad that we were out on a date. I'm not going to tell Dad we got home at 10 p.m. We were gone from 4 o'clock in the afternoon until 10 p.m. at night, 6 hours of time. And by 10 p.m., the kids are in bed. So realistically, it's a full overnight. Well, is that fair? Is that fair? No, that's not. I think
you got to hand over the kids while you get to,
have to hand over,
well, you guys make your trip to Bone Town.
Well, take it easy. But yeah, that is not fair. So let's say that I start playing games that I don't tell the other parent that I have another obligation. Now let's say, because the babysitter becomes very obvious because the kids are like, hey, there's this random person watching us. But let's say the kids are so used to going over to grandma and grandpa's house. Like, let's say they call him Gigi, right? Well, we were at Gigi's house. Oh, you were? Why were you at Gigi's house? Oh, because mommy went out on a date. Well, that's funny. She didn't call me. And you guys could have been with me. But they start using the grandparent or these other third parties as an alternative to needing to provide notice to the other parent. And they do it so often because they're traveling the world or they're living their best life. They do it so often that it actually becomes pretty significant. The grandparent or the other people are getting more and more and more time that you as the parent could be having with the kids. or the kids could be having with you is the better way of looking at it. They could be benefiting from living their dynamic in your house, in their second home, in their home A versus home 1. So that might be frustrating. That might be the basis for filing a motion. Easy. The flip side of this coin is, let's say that the grandparents are involved in every step of the way. The grandparents are the alternate care providers. Parents can't afford daycare, so they use the grandparents as daycare. So mom or dad drops the kids off at the grandparents' house before they go into work, because the kids don't have to be at school until 8, but mom has to be at work at 7. Okay, so they drop the kids off at grandparents' house, and the grandparents are responsible for getting the kids ready and going to school. Well, dad, during that time, dad's at work at 9. So he could, but is that really conducive to being good for the kids to drive them all over here if like grandparents live there and they've been doing this for the past 5 years? No. So the grandparents have been involved in this stage, or in this process, the entire lives of the kids. So what we do is we create an exception within the right of first refusal. We say that the parent must provide the other parent with the right of first refusal if they're going to be absent from the children for more than 3 hours at a time, unless the kids are left in the care of the grandparents. Oh, easy peasy, done. Very easy. It all depends on the facts of a case. So when she is trying to say here, generally speaking, what a right of first refusal is for, she's just wrong. She's just wrong. The number of times that we litigate over rights of first refusal, all the time. And the number of times we actually end up coming back to court on contempt or modification, all the time. All the time. Oh, and Cynical Girl, we will put, so it's not just like 3 hours. Usually there's all different kinds of caveats. Can't watch the kids for a period of 3 hours or more, not including time when the kids might be in school or after school activities, not including any planned overnight visits with friends or sleepovers. We put exceptions in there to make it clear. Oh, Jade, I love this question. Thank you for asking this one. Don't divorce attorneys become very cynical about marriage? They see the worst of what marriages can do to people. Thoughts? No. I think some do. Thanks for streaming tonight. I've been dying to hear what you think of this aspect of the trial. Some divorce lawyers get jaded. Some of them realize family for what it is: complicated. It's difficult. You have to work to make it work. Yeah, you have to put in time. You have to put in effort. Sometimes you're going to disagree. Sometimes you have quirks. Sometimes, in the case of Mrs. Runkle, your husband has significant ADHD, back pain, and chronic pain, and can't sleep still all the time, and is up at random hours of the night and makes really spicy stuff to eat for food. You make it work.
I will make a milder version for her, and then I'll add hot sauce for me.
See, you make it work. So no, divorce lawyers. I'm a divorce lawyer, and I'm happy as can be in my relationship, because you see the best and the worst, and you choose to model the best, and you choose to kind of use the worst as an example of what not to do. Just saying.
I was just about to ask that. What is the purpose of that?
Well, the purpose is, if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not, if my rule, or what I tell my clients is, if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or, anything like that.
Catch the other one? Maybe not sleepovers that are pre-planned. Maybe not nights with
But
grandma.
it might indeed be to prevent them from spending nights with grandma.
Yeah, like that's you. She's misreading it. And honestly, if she was going to take this, she knows better. If she was going to take this position in front of a judge, I would win 10 out of 10. It's a stupid position.
That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
Oh my God, false. Oh my God, false, 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 false. Let me give you another example that is not so extreme as to be a convicted child bad person. I'm not going to say it myself and strike my channel by myself. Let's say hypothetically the grandparent has Alzheimer's. You think that might be a reason to not allow the child to be in the unsupervised care of the grandparent? Or let's say the grandparent has a heart condition where they have a pacemaker and they are prone to heart attacks. You think that might be another reason? Or, I mean, there's any number of reasons why you wouldn't allow someone to be in the care of somebody else without supervision. Holy shit. Like, let me count the ways. Let's say, yeah, narcolepsy. There's a good one. Meme Express. Narcolepsy. Yeah, narcolepsy. Good one. Narcolepsy is a good one. Oh, what she has seen, I guarantee you, she has seen the examples I just gave you. 1,000%. Or they are alcoholics. I guarantee you she's seen it, though. That's why this is bullshit. If she hasn't seen this in 37 years, she's full of shit. There's no way. There's no way. Think of it this way. If I've litigated this issue at least 3 or 4 times in the last 10 years, I cannot imagine how many times she's litigated the issue in 37.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markell filed?
I think it would have been similar to what Ms. Adelson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his violence?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert by role here. You know, it was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have. And that's one of the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that. And
this is also where Zellman, like, he crosses into a line. It's like, really, did you really want to ask that question? It was pretty fucking stupid to ask that question. Let me rewind a second just to play it again.
Wendy Adelson or my
allegation and addressing them.
Should Wendy Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
How would she know that? Like, how? Tell me, describe to me the number of conversations this person actually had with Wendy or Donna Adelson.
This person?
Yeah, this person.
0.
None. Yeah. How would she know that?
It's a nice round number.
Just why would you, as the
roundest of
attorney?
numbers.
This is just, when Georgia Kaplan heard this question, there's a reason she didn't object. This is a 100% objectionable question, but there's a reason she didn't object. Go ahead, feed into the speculation. Let me just rip you to fucking pieces on cross-examination. It was so bad, so stupid. Would they have been intimidated? How the fuck do you know? How do you know? I get motions that get filed all the time that sanctions, monetary sanctions, incarceration, every known threat in the book. You know what usually when I receive such a motion that I have to forward to the client, I do the following. I call the client. Hey, client, I'm forwarding you a motion. I want you to skim it, and I want you to call me right back once you skim it. Okay? I'm going to give you about 4.5 minutes, and then I expect your phone call, or I'm going to just call you. Send them the motion, And then I call them because I know that what they are going to read is going to blow their lid. Like they're gonna lose their shit. They're either gonna be scared out of their fucking mind or they're gonna be furious. And I can't have them going off half cocked, scared out of their mind or furious.
They have to be full cocked.
Full cocked. We only accept full cocked discharges. God, it's so bad when you say it that way. Wow. It's just, but that's technically correct. Right? That was technically the correct nomenclature. Like I used the right words. It just sounded terrible.
You used the right words. It's just, it was very, very wrong.
It was horrible. It's almost like, you spread the full load on the bed. God, these trials all compound. It's amazing. I love it. God, it's so funny.
They shouldn't have. And that's one of the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense. And I wanted to get Kristen's take on that and see if she agreed. And she did. And she said that she had advised Wendy of that. And that's what I would have expected from her.
In the emails or text messages that you reviewed, did you see any communication that indicated that my client, Donna Adelson, was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendy had sent her mom a couple of documents. I know the petition for relocation that Donna
just you know better. You know better. You know better. You know better than that. You're not
helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because like since that relocation is extremely difficult and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication.
You saw interlineations on the actual petition from the mom? Uh-huh. Yeah. Yeah. Also very common, very, very common for me to get discovery responses back or get a pleading back or get something back from a client. And the paramour, the significant other that they swear to me did not exist, is seen in the comments, like as the computer did the editing of the document. And then I have a very firm and frank discussion with the client about, hey, don't be this stupid. Don't be this dumb. Or I get it from the other side, where the other side sends over a document that they clearly didn't look at because the document still has those interlineations from the other person's significant other. I've used that in court before. That's really fun. You're like, they said they're not in a relationship, but this is a document that they provided in discovery, and these are interlineations by the boo-boo on the other side. Like, yeah, it's yes, track changes snitches on everybody. Yeah. This is dumb.
About sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markell have been able to sustain his burden of proof for that motion?
I'm sorry, say that again.
Would Mr. Markell have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about 1.8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay. And I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just there's.
That's probably true. We're not going to talk to the kid about whether the child thinks his dad's stupid. But if it's like an allegation of abuse, yeah, the judge talks to kids all the time. This is dumb. You don't know that. You don't know that. How do you know that? Why would you openly speculate on that? Like, why would you do that? It's just dumb.
So much worse that goes on. That's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
You don't know that.
Typically doesn't tell us anything about this case.
I know.
A hotly contested case or a high conflict case. How many pages are in the court file?
think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Okay. Do you know?
Did she say pages or documents? 570 pages total in the file?
That's not a whole lot.
That's not a lot. That's the point. I don't think this was hotly contested in that sense, but you can't lie to me and say that there weren't issues that were driving people crazy. Like, I get it. And this is where people are going to disagree with me. This divorce is not overly complex. It is not what the prosecution made it out to be. This highly contentious back and forth, both people going for the jugular. It's not that. It was emotionally charged. It was. There were things filed that were pretty serious and significant. Yeah. It was litigated. But if you were to tell me that this back and forth, that this divorce file, reading the pleadings themselves, this is what the cause was for the murder plot, I would have said you're out of your mind. No one would plot a murder based on the allegations in here. Unless someone was very, 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 very motivated and just extremely power controlling and couldn't possibly understand that their daughter or other person wasn't pushing hard enough. This is why I don't buy Wendy being in on it a little bit. This divorce file does not read like that. There's the back and forth, but these pleadings are pretty standard. I see worse than this on a Tuesday. I saw worse than this today. That said, everyone's a little bit different. And I have seen cases where it feels like the parent is litigating the case and not the actual party. I've seen cases where I feel like the dad or the mom is the one that is pulling the strings, and my client would be fine. Right? I've seen cases where my client would be fine with just about anything. They just want to see the kid. They just want to be involved in the kid's life. But that's not enough for the grandparent. It's not enough. The grandparent can't tolerate the perceived injustice of their child. And they demand a different outcome. God, I've seen cases that were entirely pushed by grandparents. It's why I don't buy the Wendy thing as much. Wendy seemed frustrated. Wendy filed shit. Wendy was litigious. So was Dan. But I didn't see anything in there that really screamed to me that one of these two parties would be the one engaged in that. I don't know. It was kind of odd. Well, I don't know. What do y'all think? I know that people read into this about, what about the upcoming filings by Dan going through the bar licenses? I don't care about that. I really don't. I don't think that is as significant. So there's a part where this lawyer is testifying and this lawyer is saying that this was not significant enough. And let me tell you about the lawyer-client relationship. If her colleague who represented Wendy was worth anything in terms of skill, there would be client management sufficient to basically allay any concerns, right? So when I said that a motion got filed, I'd call the client, here comes the motion, let's call afterwards. I would call the client and talk him off the ledge and be like, look, this is bullshit. It ain't going to go anywhere. Don't worry about it. We've got it. You get him back down to a state of calm. Now, here's what I can't control. I can't control whether that client is going to get off the phone with me and immediately call their mother. And then Donna, in this situation, the hypothetical mother, is just all of a sudden re-inflaming every single fear that I just worked so hard to calm down. I don't know. That's why I can't see this. I can see Donna. I can see Charlie. I can see them. Wendy's a bit of a stretch for me. Harvey, I don't buy. I think Harvey was just in the dark. But let's go to cross. People want to see the cross. They want to see George destroy this witness, and it's why it's kind of difficult. This witness, she's a damn good lawyer. I imagine she litigates fiercely. I imagine she understands the law very well. I imagine in court, I'd hate to be on the other side of the aisle. I actually probably like it. The back and forth, the fight. She's probably really fucking good. But she's disconnected from the reality that exists in the mind of the jurors. $80,000. I'll give context when that comes up.
Yes, compared to many. Discovery issues, they case compared to he was drafting a law review article or something. There were essentially.
And why would your opinion about whether it was a
highly contentious custody case, essentially?
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody.
God, best fucking question right off the bat. The best question right off the bat. Like, why would we listen to you about this? Did you know the parties? Did you know Dan?
Do you have any business testifying about this?
Do you know what was important to them? What have I told you guys endlessly about family law? Talking to the clients and getting understanding of what their priorities are. Everyone's priority is different. To some people, money means a lot. To some people, money doesn't mean shit. To some people, custody means a lot. To some people, just participation in like baseball means a lot. What's important to them?
Else to decide. I mean, I've done 2,000 cases or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
So
but
isn't
sure.
the contentiousness in the eye of the beholder in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree with
one
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer.
There's a bit of I'm gonna slow this down in real time. There is a bit of humor in the judge's voice that you don't often hear. And I caught it immediately. Hang on. These are both, by the way, I made this comment before, and I made it like when I was watching Recovery Act when he was covering this. Do not mistake that the person that is on the stand is a trial lawyer and is not used to having the mic taken away from them. Same with Georgia Kaplan. These are two litigators that are not used to ceding control to anybody. Now, I've always said that the person behind the podium can get away with a lot more than the person on the witness stand. And that holds true. Especially here.
Contentiousness in the eye of the beholder in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree?
There was a little bit of the judge in there that was like, all right. I know you're both trial lawyers, but one of you has to shut the fuck up so the other one can ask the question and give the answer. Like, I got the biggest kick out of that. Judge Everett's like, okay, chill the fuck out. Chill out. Even he enjoyed it a bit. He's going, this is, he kind of knows where this is going. Do we go 1.5? Yeah.
That a case as a lawyer might be routine.
Nope.
Whereas
We're going 1.25. 1.5 is just, they both talk fast. No.
to the parties, it's the most important thing in the world.
To some degree, that's one reason I called Kristen, is Ms. Adelson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, We reach resolutions that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what you communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but.
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be.
Yeah. Why are you fighting that point? Like, I will be the first one to admit to you, I have to do a whole lot of therapy work to my clients. Like half of my job is managing the client when these things are inherently emotionally charged. Like, tell me a case where someone files a motion that says, by the way, your mom can't be around the fucking kids, and you're not at least a little bit pissed off by it, no matter how it's phrased. It's a dumb answer.
But in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce.
It just, oh my God. I made the comment, like, the person at the podium is allowed to say a lot of stuff. The person on the witness stand is not. Like this. Well, why can't you just say, as lawyers, we see some shit? Just say it. Just say it. Ian, as a lawyer, have you seen some shit?
At least like 50% shit.
Yeah. Like, just say it. God. Why can't it, and it doesn't blow the case. It doesn't blow the case. Just, you didn't explain it the right way. Oh my God, it's so bad. So bad.
Worse, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
I don't.
Why? This face. Thank you. Best pause game ever. This face right here was my face when that analogy was like, how do you not understand what I just said?
Well, and the problem is the jury understands it just fine. And when she says she doesn't understand it, the jury's sitting there going, yeah, you do. Yeah, you do.
Yeah. Like, just you don't think that you get numb? Like, you're just throwing around the $80,000 like it's not a big sum of money. Yes. To
800,000.
To me, well, no, because they talk about the $80,000 that was owed. Like the 80,000 in the he owed her.
Right.
Like, it was just $80,000. What the fuck are you talking? Like, I understand that lawyers deal in numbers that are oftentimes just holy shit. No. And Pokers, I want to make this point. I do not think she's a bad family lawyer. I don't. I imagine she's damn good in court. I really do, because you don't get to where she is without being good in court, which is why I'm shocked that these answers are coming across the way they are. You know better, ma'am. You know better. You are not dumb. Like, you're not stupid. $80,000. Let me give you an example. $80,000 is a huge amount of money. It is. It's a huge amount of money. Divorce litigation in a contested divorce case will run at a minimum about $25,000 to $30,000 in a contested case. On average, around here in Northern Virginia area, you're talking a divorce case. Let's say you have 0 children, contested divorce, about $40,000 through trial. Let's say you have children, contested custody and divorce and assets. You're talking about $80,000 to $90,000, almost at a minimum. It is not uncommon for attorney's fees in divorce cases to get upwards of $200,000. And don't get me wrong. It's not the greedy lawyer that's taking the money, because it's a shitload of work. Remember I said the thing about dividing something that's not intended to be divided and doing that against an opponent who's equally motivated to make sure that you don't get a single fucking dime? Yeah, it's a lot of work. Trying to get documents on assets that have been hidden. It's a lot of work. The most contentious divorce case that I've seen around here recently was about $400,000 per side. One side spent about $600,000, $400,000 per side just to get to the final order of divorce. And that's attorney's fees only. It's nothing else. So yes, lawyers can get numb to money, or at least talking about the sums that are involved. At the end of the day, I look at a client. A lot of times I will look at a client, and when there's a $25,000 to $30,000 disparity in what the offer is, right? So the other side's like, I will agree to all of your proposals, but you pay me $20,000 in attorney's fees. I will sit down with that client and I will say, this offer on what the merits are or what the actual disposition is ain't bad. It's a good offer. It is what I think is better than what I think a judge is going to give you. And they're like, but I'm not paying her a dime in attorney's fees. Okay. Pretend like you're paying off an old credit card. Like just pretend. Hey, pretend like you're paying it to me. Pretend like you're paying it to me to try the case and get this outcome. Because that's what's going to cost you to go to trial. This is why that's I know. I had that discussion 2 weeks ago with a client on a settlement proposal. And that client called me back 5 minutes later and they said, accept it. I have had clients, though, say I'd rather pay it to you and get less than what they're offering than pay her another dime. I have had clients do the principled argument, and I was like, hey, as long as you understand that that's the decision you're making, that's your call. But to pretend like it's not significant,
I will accept any trivial $80,000. If 80,000 is trivial, then I will take trivial sums. Find me on my channel and hit the super chat button for a trivial sum.
Well, and this is why when people talk about like divorce, like the comment was made earlier about divorce lawyers being pond scum or the individuals that are bottom feeders, not the good ones. Because I have that discussion with my client. And I'm like, look, it's a good deal. They're asking for $10,000 attorney's fees. You can give me the money or you can give it to them. Either way, it's out of your pocket. The only thing is, if it's out of your pocket when it goes to them, or if it comes to me, I can't guarantee you're going to get this outcome at trial. So give them the money. Don't give me the money. I don't ask for the money. I want the client to get the best deal. I want the client to be happy. So no. So yeah, this is numb. This is just someone who's disconnected from reality.
Or is being evasive.
what is no big deal
Just
to
in the
us
chat.
is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
That
You
was
were
stupid.
asked.
That was bad.
Let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law
I've
litigation?
never had anyone murdered. I had in one instance, a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was, it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
Right.
that person, it was a reason to commit suicide, right?
Apparently so.
Why? Just the way that she answers is just terrible. It's just a bad.
Oh, she's very much.
It's a bad
It comes
answer.
off like she's motivated, right? It comes off like she's very. She's picked a side.
It's just a bad answer. You're gonna, if you're gonna cite an example. First of all, if you're gonna cite an example about an individual who committed suicide during one of your cases, I imagine that you probably know more of the circumstance because there's probably a fair bit of trauma that goes along with that. I have not had that happen to me. One of my partners has. It was the opposing party. The day after the judge entered the ruling against him, which happened to be the day after he cross-examined the hell out of him on his alcoholism. So, I guarantee you that has stuck with that lawyer, my partner, for quite some time. And he'll remember every single detail about all of that. Probably remembers the exact questions he asked during cross-examination. It's enough. I remember I've had two clients die. One was surgery. The other one was a medical condition that we didn't know about in the middle of divorce litigation, in the middle of custody litigation. And I remember every circumstance about that because of how painful it was to watch the family of my client who had just passed away scrambling to try and figure out what rights they might have had to the custody or to visitation or to see the kids. I hated it. I remembered every second about it. That's why I hated that she said, I had one case and it was because he committed suicide because he couldn't accept the shame. Really? Really?
Yeah.
Like,
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset.
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't.
Exactly.
It should have.
yeah.
There was no proof.
Well, both of you get yelled at for this. Georgia, shut up with the exactly. Bailey, shut up with the continued talking. Like it was at this point of the cross-examination, I got frustrated with everybody. Georgia, you don't get to give commentary on the responses. You don't. I know that this cross is good and you make good points, but you don't get to give commentary on the responses. Bailey, there's not a question pending. Shut your fucking mouth. Oh, I hated this.
It shouldn't have been in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties.
She's
right?
like, not to me.
Right?
Sure.
She's like, I wipe with that kind of
I
money.
think on that issue, he clearly
Just it's the filling the gap with additional conversations. Ladybug Lisa, she's probably getting 80,000 to speculate. If you're gonna answer that 80,000 is a lot to some people, but not a lot to another, then give a more full answer. Like I've had $80,000 is not a lot of money to someone who has 5.5 million. But the thing is, you don't want to give that answer because the question comes back is, did Dan Markel have 5.5 million? I don't think the answer was yes. Just this thing goes off
had the
the rails.
asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay or he was going to get sanctioned by the court or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you?
I
And Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
Ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the
That's
key
Florida.
is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
Yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor. No question.
Yeah, that took a while. If I was the tell me you wouldn't have objected like 15 times before this with the commentary.
I was wondering where the objection was, except I know this defense and I know that they don't really do a whole lot of it.
I think it was a bad strategy move because it lets Georgia get the upper hand in all of these cross examinations.
The thing is they promised to the jury, we're not going to try to hide anything. And it was such a terrible move because they just keep getting clowned on as a result of it.
These are all objectionable questions. Now, thing is, she starts going to open speculation, but the problem is, what's good for the goose is good for the gander. So Zellman gets to have his cake and eat it too, which is you got to speculate. Now she gets to speculate.
Strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on that witness's testimony.
Please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. You don't send people to jail for failure to pay money. We don't do that.
Oh, well, Virginia does. So I don't know about Florida, but Virginia does. So don't pull this shit in Virginia.
The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support. And if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever. And then all of a sudden he comes up with money out of his pocket and he pays, he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if you wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay.
What? Did she just say that? She's seen one person in her whole career go to jail because of child support? There's no way. There's no way.
You're like, I've seen more than that in the last 10 minutes.
Well, not 10 minutes, but like I've seen more than that in the last 2 months. There's no way. Now, do they get out of jail within the next 5 days because all of a sudden like a car gets sold and they have the money to pay it? Usually. That's
because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't. And that's just support. That doesn't, there's no jail consequence to the 70,000 to Wendy. It was only the 10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Ms. Adelson, Ms. Donna Adelson, about relocation.
Did you see any emails from her at all post settlement?
Not until maybe December. It was a while. October, maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post denial, post stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
I'm pretty callous about the well, obviously part, right? Like, just, like you would just expect this is part of the reason why you don't put a lawyer who's been doing this for this long up on the stand. Just don't do it. They're just not going to talk in a way that other people view as being normal. What the hell? Well, obviously.
She's a bad witness.
Yeah.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law. And I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud. And it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right. So they weren't.
Okay. That's really cute that you think that. Do you know how many lawyers walk into court every day and think they're going to win their motion? All the time. Like, how many lawyers walk in? Heck, I wonder if Donna Adelson's lawyers walked into court yesterday and were like, hey, our client's going to get acquitted. Maybe they thought it really hard. And that was the thought. But, yeah, doesn't mean anything.
Sadly, I must go because I've got to be up in not too many hours now that I think.
Oh yeah, crap! I just looked at the clock. I've got a obligation I have to be at too. All right, buddy. Sorry, I didn't mean to keep you.
5. It's gonna suck.
Yeah, I've got to wake up around 5:30 too because I've got to be out of the house at 6.
Good night, all.
Night, buddy. Thank you for being here.
Oh, thank you for having me. It's always a good time. So, cheers.
Adios, amigo. I'm looking at my mouse because my mouse is running out of battery, but I don't know how to charge it because it doesn't have. Oh, there it is. I found the charging port. Ooh, which means I gotta find a battery. Because this is gonna be fun. Okay. Good night, Ian. We're gonna watch the end of this because I'm about to find a battery because I can't actually click things on my screen without a battery. It's fun. I like that. I like that. It's a twist. It's a twist to what is otherwise a very effective live stream until the battery on your mouse runs out, and then you got to figure out what you're gonna do. So we're gonna watch this until the end, which I think is coming up pretty soon. I'm gonna sprint to get a battery. Yeah, I do know that 5:30 is about 4 hours. I'm aware of that, which is why we're gonna watch the end of this. I'm gonna wrap that up, and I'm gonna go ahead and do super chats and get out of here.
Going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
Right. And that case, was anybody murdered in that case?
No.
Okay. So if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Yeah, the demonstrative like totally fails there. Yeah, that's sometimes a long pause can be both good. Sometimes it can be good. Sometimes it could be like the death nail, like the long pause that exists back here on the demonstrative case with all the binders and the paper.
Case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter.
Yeah, that long pause is like the death nail right there. That long pause was. That's your answer.
Somebody gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing March 15th. I mean, excuse me, May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markell filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markell amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markell's murder, litigation was still ongoing in this case.
Yeah.
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Overruled. The witness has provided an opinion. The state will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened.
Okay, we're back in business. We have batteries. All right, so we did the fee thing on the encouraging your client to go forward with trial because you might get attorney's fees back. There's a point where that actually gets made, but this is really, 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 really dumb. This is when you double down on something stupid. You have seen the case file to date. You have seen the motions back and forth. You have seen that at least Dan, from my reading of this or from my understanding of this, is filing a whole lot of motions that seem to be rather lengthy on issues that might appear trivial, might appear significant, but he's definitely filing motions. Here's my thought process on this. If I was going in and understanding the divorce the way it was, Let's let her finish testifying, then I'll give you my thought process and wrap up.
Yeah,
And we'll never know when that was going to happen because we never got to that point, right?
clearly,
Because he was murdered.
clearly.
Clearly.
May I have a moment to confer, Judge?
And I thought missed opportunity. You wait for the objectionable question, like just hang on to it for a second. Like go back, confer, but have one in your back pocket. Like my favorite trick, is to ask the court for a moment to confer with my client, but I have my final question in my back pocket. It's objectionable as hell, or it's like the slam dunk question, and I confer with my client, and I come back and I ask that one question, and I sit down because the objection doesn't matter at that point in time. Point's made. But I think she is done. And then Zellman gets up and then tries to relitigate the entire direct examination all over again. It was exhausting. Oh no, he doesn't. There's no redirect. I wonder if she was looking for something there. If she thought that there was something that she could bring out. Did see a note that people were asking what the box fort was, so we'll zoom back to that just to show you what it was. There's no question, but here, there's the box fort.
Volume 4. Volume 5.
There are questions of the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
And this are these 10 volumes, a example of a hotly contested relocation case.
Well, and I just count 500 pages per binder. So that looks to be about 5,000 pages. I think the actual pages were over 10,000. So this doesn't appear to be all of it.
Okay.
Yeah, that's not bad. The number of boxes I bring into court all the time is a pain in the ass. I'm trying to go digital, but this is the demonstrative. This is the demonstrative relocation case that she was trying to say. Now, how she got to use this, I don't know. This seems like a big stretch. I don't know why the judge let her get away with this. I would have objected to this. Like, you don't get to use a random case to say that this is what a contested divorce looks like or a contested relocation case. Because I don't know if those binders are pleadings. I don't know if those binders are correspondence. I don't know if those binders are discovery. I don't know what the binders are. They could be anything. I have 10,000 pages of discovery in cases all the time. I don't print them all out and put them in binders because I don't need all of them. So this doesn't really tell me anything. Yeah, I agree. The Daryl Brooks box fort was a more impressive box fort. Oh, they did? Was it sustained? They got it out? I don't know. It was wild. How do you get to use this? Like,
And there were 2 volumes on the record on appeal. So perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
that is.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Yeah. Why didn't you object earlier? Why is that at all? How is that at all relevant? How do you get to say, I have this random case that's another relocation case that has this many binders that I can't tell you what's in there, and then somehow have that make some impact? What the fuck is that? What? That doesn't make sense. You don't get to do that. Hey, judge, I have this case with adjudication of custody of 6 different children, one of whom is completely disabled. And that is somehow supposed to correlate to this other case where we're talking about like no kids. What? No, every family is different. You don't get to just say family law case is family law case. I think that's the issue. So, that's enough of Miss Bailey. I think she's a skilled litigator. I think she probably knows what she's doing. I think she's probably been doing this long enough that she's got a pretty sizable clientele that knows what. But the point is, Every family is different. Every situation is different. Every case is different. You can't just look from the outside into a divorce case and say this divorce was not contested or it wasn't hotly contested. Do I get a measure of what this divorce might have been like based on a view of the pleadings? Probably. Probably enough to be able to speculate amongst counsel of the other side and say, yeah, this is run of the mill, looks contested, looks contentious. Parents are involved. We have possible relocation issue. Is this file, as I'm looking at this file, the file of Wendy Adelson, Dan Markell, is this file a file that is contentious enough that I would possibly imagine in a million years would result in a murder? No, it's not. It doesn't have the type of slam dunk litigation that you would imagine or that you would foresee. But do I know Donna Adelson, Wendy Adelson, Dan Markell? Do I know them? Do I know their family? Do I know what that dynamic is like? I have no clue other than what we saw in court. That's all I know. So I don't know whether it would be enough. I can tell you, I don't think the grandma motion standing alone on its face is enough. I don't think when Georgia Kappelman was trying to say that the grandma motion was the basis and the reason why the killing occurred. I don't buy that. I don't. I really don't. It is a stronger argument to me to say that the Adelson family or the collective, the Donna and Charlie gang or whoever was involved, is far more easy for me to comprehend that they were just done dealing with the person who was litigating every issue. That's what it sounded like. It wasn't one particular thing. It was that the litigation just didn't stop. It was everything. It was all of it. Litigation in divorce cases. Let me give you an example. Litigation divorce cases, the number of clients who come to me and say, can they really just file something every year or every other year? That it's like, I thought we resolved custody last year. Well, yeah, there's changes in circumstances, and people allege that there's a change in circumstance that would necessitate a change by the court in custody. But can't they be blocked from doing that? All right, let's play that out. How dumb does that sound? Let's say, hypothetically speaking, that something significant happens in the children's lives that would necessitate a change. You're going to block them from coming to court and asking for that change if something actually happened? Well, no, it would have to be legitimate. Well, how do we find out if it's legitimate? Well, they would have to prove it. What do you think a trial is? Their opportunity to prove it. So they can just file pleadings? Yeah, all the time. All the time. They can file pleadings. This is what I think people don't understand. What Donna Adelson might not have understood about divorce and family law cases. There's an adage that basically says family law and criminal law are the two areas of law with the most repeat clients. Because criminal law, you get recidivism. Family law, you get that client can be a client for the entirety of the children's 18 years of life until they become an adult. Because you're litigating issues time and time again. You don't want to. Some parents choose not to. So this was just about not wanting to be, I guess, in the passenger seat, not wanting to not have control over the fact that litigation could continue. That was my perception of it. I don't think it was the grandma motion. I don't think it was the relocation. I think it was just the totality of the circumstances that existed. They were not going to allow this person to continue to torment, in their words, torment their lives or to have this upper hand or to be able to dictate what's going on in the lives of their child for this period of time. That's what it felt like. So I that was my take. I could be completely wrong. I could be. I saw people in the chat saying, Rob, you're letting Wendy get away with everything. I'm not. I'm just giving you my read on it. It's my perception based on what I've seen. The aggregate of the circumstances that basically told them at the end of the day, holy shit, this is going to be our life for the next foreseeable future for the next 16 years. We can't do this anymore. Wouldn't it be great if we didn't have to do this anymore? All of a sudden, something becomes real. So Donna Adelson's convicted. She is toast. That lawyer did not move the needle at all. It was a bad judgment call on my part to put them up on the stand. They would have been better off having Wendy's lawyer continue to testify to that divorce case as it was, and just admit the facts as they are. Divorce is hotly contested. Divorce is highly emotional. You're never going to have something that's entirely peaceful when you have two parties that have different mindsets, different understandings. So, all right. Let's do this. We're going to swoop. We're going to do super chats. And we're going to get out of here for the evening. Thank you guys for being here, by the way. There's 3,933 of you here right now. We've been going for 4 hours and 25 minutes. So please hit the like button. Please very much do that. Also consider subscribing. I do stream only one night per week. That's what I can usually do. Just because, again, full-time practicing lawyer. And I try to make those live streams at least enjoyable for the most part. But they usually go several hours late. People always say, well, Rob, why do you look so tired? Why do you ramble off at the end? Because I've been awake a long damn time, a really long time. It's the end of my week. And I like chatting about cases with you guys. So we're swoop. And we're going to go to chats and get up out of here for the weekend. Swoop. And we haven't had enough swoops. We'll do a double swoop. Oh, okay. All right. Panthers win. Thank my Lord, y'all are here tonight. Happy to see you. Happy to see you too, Panthers win. The world wonders the problem with not paying jurors, well, is you wind up eliminating low-income working people and their experiences from the jury pool almost entirely. You end up eliminating a lot of people. I wish there was a way that we could make it, I don't know, get a broader spectrum of the population in there. It would be helpful. Not that, Janet. Have you ever seen a juror fall asleep? Almost in a depth trial, like close. They do from time to time. Yo quiero queso. Do you have to disclose if you're called for jury duty and have a learning disability? Not asking for my ADHD ass, asking for a friend. You do not have to disclose anything that's not asked of you. There's no burden on you to present court with the information other than to respond to the questions being asked of you. Like Queen, she wore red for every verdict. I know that. I saw that. And they asked her in her interview, is there a fifth red suit? And she said, stay tuned. So I guess there is a possible indictment for Wendy Adelson coming. Dreamy pragmatist. My 21-year-old got summoned. At first, I was horrified. She can't even do her own laundry. Then I realized that she would do amazing. That's the way to go. Mary Coppola. Evidently, Georgia wears a red suit. Evidently, Georgia wears a red suit for closing on all of the trials. Wendy has surrounded herself with some high-priced lawyers, one who has represented Trump. I mean, resources, here's the thing. The resources of a private civilian is never going to be the same the state has. The state has endless resources. Georgia Kaplan, the resources they had at their disposal, it's laughable at the end of the day. It really is. So I don't fault people for getting lawyers that are expensive, not when they're defending themselves or their livelihood or anything else. I just think they should make better strategic decisions on who to call. Big Apple Hoosier, she broke sequestration rules. Odd overall. I think that befalls the defense counsel, who should have informed their witness whether they could or could not sit in. The witness, from my understanding, had requested to sit in. Defense counsel did not inform that witness that they could not sit in. So I think that was a communication issue. They're allowed to testify. I don't think listening to that testimony would have changed her opinion one way or the other. I think her opinion was pretty well founded, pretty well made up before she took the stand. And I think that opinion was not really founded in anything other than just reading the pleadings and speculating. Kimberly Fisher, what she says and does on cross is going to blow your mind, Rob. It did. We saw it. I she stuck her foot down and kept it there on some positions that didn't really make sense. Zoe, prosecutor I work with, did kid cases for a year, and his idea of what is an appropriate, quote, I had this case once, end quote, story is wild. Lawyers get desensitized. Yes, they do. They absolutely do. Family lawyers, divorce lawyers, criminal lawyers, all lawyers get desensitized because they see a lot of things that people don't see on a daily basis. Nancy, new 12. What do you think of her being in the room during the argument about her breaking the sequestration rule? I don't make a whole lot of it. I don't think the judge is going to exclude her. It doesn't look good, but it doesn't look good on Donna's lawyers, not her. She is not responsible for managing whether she is or is not in the courtroom. It's the lawyers that are responsible for making sure their witnesses comply with the rules that are in place. Because she did not walk up to sidebar. The lawyers did. Heather, New Zealand Butterfly Girl, didn't like either family lawyer. First kept talking about her sister's case. She was her lawyer. What about privilege? Privilege was waived for that, by the way. Second was rude and arrogant. The rude and arrogant one was the one we watched. Mr. Sharpie, Rob, check out the newest Randall Monroe comic. You'll get a kick out of it. I actually pulled it up. I had it up. I'll pull it up again. I will. Thank you very much for the tip. I will pull that up. Nicoli, one of those two. Thank you for the very generous super sticker. Very kind of you. Music to my soul. Georgia gave a voice to the frustration that we all felt listening to this lawyer testifying, and I felt what she was feeling in that moment. The freeze frame that I got of the really, that. Why can't you just admit simple things that we all know are true? I understand from the perspective of a litigator who tries these cases all the time. Was the Wendy Adelson, Dan Markell divorce something that was overly litigious and a crazy story that I would carry with me? No, it sounded like a run-of-the-mill case. 100%. Do people act differently under circumstances that are different to them? Yeah. How can you not recognize that part? Megan Sue 819, love the both of you together. So just an appreciation post. My opinion, the jury was right, but Rob, the family court stuff was annoying. How does a lawyer testify that way? Gross. The speculation was frustrating to me. Mama Betts, always enjoy FNF. Thank you for everything. Thank you for being here, Mama Betts. Fiona W, thank you for gifting memberships. Very kind of you. Crazy Cat Queen. ANS, well, it depends on how much they are paying me. I guess so. Lori Ross, I think they have a lot on Wendy that we don't know yet. I believe that 100%. I truly believe there's still more surprise to come. I also believe that as well. Big Apple, Hoosier. How about when the first lawyer claimed she had a few divorce clients get murdered? What the fuck? I have not had a client get murdered, and knock on wood, I will not have to deal with that. That sounds pretty wild to me. So we're just gonna I'm gonna stay on this boat as long as I can, where my clients are not getting murdered. Southern mom got divorced with young kids. My attorney gave me the best advice: put the parenting plan in a drawer and never look at it again unless needed. My ex and I have been awesome co-parents for 10ish years. Southern mom, that works great when your ex agrees to do the same thing. I always want that to work. I always want two parents to just be parents. Don't focus on what the order requires. Focus on what the kids need. And if you both have a good mind about you, and if you're both focused on the right thing, you're going to do the right thing. But sometimes parents be children. And when they're children, and when they're vindictive, or when they're frustrated, or when one person was motivated or not motivated, it changed the dynamic. So I'm glad it worked out for you. And I always wish that for all of my clients. But to the extent that it doesn't go that way, that's why I'm here. Why the lawyers are here to help resolve those issues. Crazy Cat Queen. She was brought in to essentially validate Wendy's attorney's actions as correct, and it wasn't contentious, wasn't she? Yep, that's pretty much what it was. Devious. My sister's ex proposed that she take the kids to temple on Friday and he to church on Sunday and see what happened. So she got sole decision about religion because what the fuck? These things become contentious. When the lawyer was testifying about divorces that were overly contentious, it is cases like this, cases like that we are thinking about. People talking about the medication issue, or people talking about private versus public school. Those types of cases where people are emotionally invested in a decision that they believe in their bottom of their heart should be made and is the right call. And the other parent believes to the bottom of their heart that their decision is right. Those cases get ugly. And that's when you see the worst of the people. Not that, Janet. Rob, have any of your cases come to murder? No. And like I said, we're gonna stay on the boat of not murder. Belle got cat number 3 back from the vengeful ex this week. Well, welcome back, kitty number 3. Lauren L., she's so immersed in her, quote, normal that she came across as obtuse, out of touch, and uncaring. I audibly gasped at the self-unalived story. Just icky. The way she said it was just, yeah. That part did not go well. Jordan Patterson, Rob, got to be on my first jury a few weeks ago. Was a DV case. Wow. Had to remind them multiple times to not talk about the case. Glad you were able to remind them to not talk about the case. It is difficult not to, especially when you're hearing the evidence come in and it's like, holy shit. A lot of cases that go to trial are not complicated. It is, this is what happened. Here's the footage showing it. Are they guilty? And you're like, well, yeah, I see it. So that's a tough case, though. Nancy knew a lot happened on October 31st, 2013. That the timeline is rather complex in this case. Bell, thank you for the gifted membership. M169, right of first refusal is the plot of Mrs. Doubtfire. Kind of is. Yeah. Dreamy pragmatist, DM lawyer said, Dan Markell lawyer said he had given Wendy's legal team notice that they would have filed fraud charges on July 18th if they didn't take steps to correct the financial issues by then. Scary. Not necessarily. I do agree with Ms. Bailey in this regard. Lawyers put a lot of shit in pleadings. It's not very easy to intimidate another lawyer, especially when litigation's been going on for a while. So I don't necessarily think that meant anything to the other lawyer. I mean, it might have meant something to Donna, maybe, but not if the lawyer was any good explaining it. Annabelle Feinstein, my second divorce was a lawyer's dream. Pics of him cheating in the act, married 6 weeks. I wanted out in payment for my stuff he gave his mom without permission. Video proof of him taking the stuff. God. Some people just don't do things intelligently. And in your case, it sounds like he did not. Crazy Cat Queen, how about a grandparent who wants to dress them up in historically World War II German outfits? As far as the supervised versus unsupervised, that wouldn't be the be all end all, but that would be a decision or consideration the court would give. Apocalypse DOA, Alzheimer's in Florida surely never happens. Oh, on the unsupervised? Yeah, surely. They've never come across that. And Bill Feinstein, part 2, he was Air Force. It could have ended his career. Adultery is a military crime. It gets people in trouble in the military a little too often than not. Doesn't excuse the conduct, but you don't want to end the person's career because usually sometimes they're the livelihood that actually helps put support being paid, etc. Jag will take it with the pics. I let him pay me for everything and walked away. Best move ever. Walking away and starting a new life is oftentimes a lot more rewarding than trying to gouge the individual. Troublemaker Baker, thank you for gifting me 5 memberships. Very kind of you. And I love the avatar. Cookies look great. Those waffles, cookies. Wonderful. Stevie G, their expert didn't feel very expert-like, felt more like they had her come up and gush about how good her bestie is at her job. It was more giving generalities and speculation that didn't really have a lot more in foundation other than I've seen a lot of divorce cases and blah, blah, blah. And I say blah, blah, blah because it's like some generality that might not apply here. fill in the blank. AG, hey, Robin, Ian, happy Friday. Passed my first speed test at 80 words per minute. Phenomenal. Good job. Jury charge and am working on my speed building. Also down 31 pounds this year. Congratulations. Wanted to celebrate with my favorite YouTube lawyers. Congrats, AG. That's awesome. Great to hear. Henhouse Bath Company, Mod Squad tuning in, celebrating that my business was featured in a local magazine this week. Congratulations, Henhouse Bath Company. That's phenomenal. Go check out her stuff, by the way. Really cool. Candle smell wonderful. Jay Cash, please stop saying you don't believe Wendy was involved. It goes far beyond those divorce papers, Rob. I don't know. I don't know enough about Wendy's involvement. I didn't watch Charlie Adelson trial. I watched Donna. I watched this trial. And with this trial, I saw Wendy testify. There's more there. I just don't know if it's enough. But I don't know what else Georgia Kaplan has. I guess we'll have to see. Nebraska Jeff, Rob, how well do prenups actually hold up in court? As with every family law case, it depends. Very fact specific. Generally speaking, at least in Virginia, prenups are enforceable. It's very difficult to set them aside. Very difficult. Mrs. Squirrel, motion for pup picks cleansing. I can try to find one. Jade, you think those binders were full of blank pages? No, they were probably her file. I really do. Imagine that they were a file in another case that she was working on. And she just was like, look, this is a relocation case I have. This is how complicated it is. Just the context doesn't really work. Oh, I found a good pick cleanse. There's fucking goofball. What an idiot. What an idiot. And by idiot, I mean like handsome devil that. Here, pup cleanse. You want the pup pick cleanse? You can do that. There's the puppy asleep with his face all smushed. Smush face. Smushy smush face, Leo. I sigh with exasperation because that dog is wonderful, amazing, adorable, and also torture. Just saying. Like equal parts too. Equal parts chaos and love. It's a lot. Dobermans are a lot. He is handsome though. Yo quiero queso. This lady does better stretchies than my dog. Yeah, I had a lot. Catherine Fallon. I've had friends who went to jail for not paying. It is. She's like, it's so rare. No one ever goes to jail. Really? It happens all the damn time. Jeff 744. Thanks for becoming a member. Much appreciated. Tomato Cheeks. Thanks, Rob. Have a great weekend. Everyone, have a great weekend yourself. Cub, Hubs, and I waited all week for your take on her. Thank you. Thank you, Cub. I was less critical of her watching her first go round. Second go round became even more frustrating because I was like, really? You're just going to ignore those things? All those things? We're not going to talk about it? We don't talk about Bruno? We don't talk about Bruno. Oh, there's another cute one. Not me just totally looking at pictures of dogs. Here's another one. Not ADHD isn't firing off at all. Look at that. It's a boy. The big boy. With his paws tucked up under him. Yeah. He's a handsome. He goes to the bus stop with us every day. Kids love him. The kids love him. They all run up and they all like pet him before they get on the bus. He is now just the bus stop mascot. It's really cute. Really cute. Y'all ain't right. Rob, I have control over my kids' education, religion, extracurricular, and medical. What does that tell you? That tells me that, tells me the person on the other side either doesn't care or you've got the better judgment by a long shot. Like I said, I don't know enough about the family to read into it, but it does suggest something when those decisions are being given to you exclusively. Annabelle Feinstein, marriage 3 for the win, 15 plus years and going strong. Congratulations, 15 plus years. I get up often at 4:30 a.m. to make a breakfast and always pack him homemade lunch. Food is my love language. Oh, that's a love language to have. My word. Good for you. And good for him, too. Yeah. Music to my soul. Donna, quote, Wendy's getting depoted to death, end quote. Quote, the rest of our lives depends on this, quote. Also, Donna, this divorce case wasn't contentious. See, I think it's that part. It's the aggregate of those things. You can't pretend like it wasn't contentious if you are facing what seems like endless discovery, endless disputes, endless everything. Like I said, litigation in divorce cases, it can be perpetual. If you have, I have cases that I have had. I mean, hell, let's use one of our managing partners. I don't even have to. I have cases that I have had in my care for 7 or 8 years. Because they're never going to agree ever. You just imagine that. And it's not 7 or 8 years, just all litigation. Like there's like a 3-month gap or a 1-month gap or a 2-month gap. And it's just in court. They've probably spent $1 million between the two of them. And I look at that and like, it's $1 million the kids won't get. That's sad. Like I said, I can't make people agree with each other. It's pretty wild. Okay, folks, that marks the conclusion of this evening's live stream. Thank you very much for being here, sticking around with me. 4 hours and 46 minutes in. Very much appreciated. For those of you who are here, we're at 2,700 likes. Please hit the like button on your way out. There's 3,546. So that means that at least, 900 something, 800 something have not hit the like button. So hit the like button, please. Like. I want it over 3,000, please. And then for those of you who are still here, please consider subscribing. Would love to see those numbers continue to rise because I love talking to you guys and I like having big chats to talk with because all your opinions are valuable and they're all influential and they're all remarkably they contribute to the community where we get to have a discussion and learn from each other and learn about cases, all types of stuff. Hope you guys are doing something fun this weekend. Get outside, go make something. You'll feel better. Cheers to all of you. And I will do one program announcement. And I was reminded by my mods. I will not be live streaming on Friday of next week. I have all of our firm-wide all hands meeting is that weekend. So I will actually be out of town for work stuff, not fun stuff, work stuff. So cheers to all of you. Have a great weekend. Have a great next week. And I will see you when I see you probably the week after next, if I can't squeeze a live stream in between now and then. Cheers to you all. Have a lovely evening. Thank the mods on your way out. And I will see you next time.